Yeah, and that's the amazing thing. It's yet again a situation where the United States is held to a different standard than every other Western country, and it's crazy. This and voter ID, where the rest of the world lives one way but demands a completely different thing from the United States, and the United States for some reason we're like, no one will accept this idea of of denying birthright citizenship. It's like no one else does this.
No, they don't. And that's the same thing. I mean, and yeah, going to the voter ID thing, like a lot of no other countries really do vote by mail or any, like, you know, if they are a democratic republic type state where they do voting, it's done the way that it's done. We're the only country in the world that has this secondary standard of how things are done. Look at our measurement system. I mean, that's just case in point. Everything else is just basically metric, and we're weird. So again, we're just sticking to being weird, and I don't like it.
Yeah, well said. And it's I just hate this notion that this is wrong. That's said all the time. Voter ID. It's like this is wrong. It's like every civilized nation has an authentication system for votes. Every single one.
Look at what Mamdani did in New York City. At first, you had to have 5 pieces of ID just to go out and shovel snow. And then, we'll drop it down to 2. You still have to have 2 to go out and just shovel snow for $30 an hour. Like,
that's insane.
We can't have a ID to go and vote. And hopefully that's something that I hope he does call them back from their vacation and makes them go to work on getting that through. But you know what? Justices are there arguing this stuff. Everybody should be in DC doing their job.
They should be. They should be.
Course on Wong Kim Ark, and you disagree with their interpretation. Oftentimes, when you are dealing with a constitutional precedent like this, you might argue, we disagree with that interpretation, but if you adopt their interpretation or agree with their interpretation of that precedent, you should overrule it. And you haven't made that argument here, and I'm just giving you an opportunity to explain why you haven't.
Because we think it's totally unambiguous in Wong Kim Ark that the holding relates to domiciled aliens. And so we strongly agree with the holding. We think domicile was the touchstone, and we think that's not a coincidence for the reason that I maybe speculate a little bit when I was talking to Justice Gorsuch about how the dissent raises this, and then the majority's like, we're putting domicile in there, so we know that the absurd conclusion that they say would come from this isn't there. But also domicile as kind of the sort of relationship that creates this relationship of allegiance that makes you part of a political community if you're an alien from another country. That's deeply rooted in their understanding when they're doing it. They talk about domicile in Yikwo against Hopkins in the 1892 and 1893 cases, and there's this deeply rooted understanding, again, that goes all the way back to the early 19th century. So we think that's a really important conception. So I mean, we disagree with some of the dicta in Wong Kim Ark that we discuss, and we think there's dicta that goes our way that the other side overlooks. And we're not asking the court to overrule dicta. We just say don't follow erroneous dicta and don't apply it to this brand new situation that was not decided in Wong Kim Ark.
Thank you.
You can eat this dicta.
So General Sauer, I want to zoom out a little bit and think about jus soli and jus sanguinis. So as I understand it, at the time of the 14th Amendment, those were the two dominant approaches. Jus soli, the English common law, roughly following the soil. Jus sanguinis, roughly citizenship following the parents. Now, jus soli was very generous on the soil, the English common law, and so it extended citizenship to those born there who may not have been born of parent citizens. But jus sanguinis, if parents who were citizens and had a child abroad, then that child's citizenship followed the parents. So one thing that's puzzling me about your argument when I think about the ratification of the 14th Amendment, in many ways it would have made sense for them, and you acknowledge the jus sanguinis in citing Vattel. It would have made sense in some ways for them to say, okay, we're going to follow, if they wanted to accomplish what you're saying they wanted to accomplish. You could say, well, we're going to follow jus sanguinis because we're going to make it all right on parentage. But instead, I mean, the 14th Amendment, we're talking about subject to the jurisdiction thereof, but it also says born in the United States. So you have the jus soli kind of point there, but you're saying it narrowed that point by tying it to the citizenship of the parents, at least as to soil. But I take it you're not arguing that United States citizens who have children born abroad would qualify for birthright citizenship. So it's kind of a narrower view of both the traditional jus soli rule and a narrower view of the jus sanguinis rule. So why would they have done that? And if they were going to invent an entirely new kind of citizenship, like an American brand, why wouldn't we have seen more discussion of that in the debates?
I think you do. And I would say, I think the right way to conceptualize it, it is a modified jus soli. Because even the British sources don't just say you're born here, you're a citizen. They say you're born here and you have to be under the protection of the sovereign. You have to have a relationship of allegiance. Allegiance is the word in Calvin's case.
But they don't focus on the parents, it's the child. And your approach focuses on the parents' allegiance.
Yeah, I'm not sure that that's true of the
Seems a
19th
little
century.
ambiguous.
It's not true.
No.
Also, Gorsuch asked the exact same question.
Yeah.
He asked the exact same question. He said, "Oh, the focus on the child's domicile, not the parents." That's not correct. The idea of a child's domicile would imply that the child has the capacity, the recognized legal capacity to make a decision about domicile, and they didn't. They barely do now, only if emancipated, and only if the state permits it. If a child is denied the right to assert its own domicile, then the child is a ward of the state, and the state that the child is in exerts its jurisdiction over the child at that point, and the child does not have the legal capacity to choose domicile. This is crazy.
No, absolutely, and I agree. And doing what I do, like I've literally had cases where I've had a minor that was a parent, so a minor that is responsible for making decisions of another minor, but they can't make their own decisions because they're still a minor, so their parent is still the one making the decisions for them. So, you're looking at a situation that you have, again, it's all about the domicile. But going back to the allegiance thing that they're talking about, I'm sorry, do we not see the protests that are happening in our streets all the time of all these people that are here in America that are still showing their allegiance to the other countries, where they're raising Palestinian flags, or they're raising, Mexican flags, they're raising all these other countries' flags? If you're going to have this where you're a citizen of the United States and you're subjected to the jurisdiction because you're here, then your allegiance is to the United States, then your allegiance shouldn't be to the other countries as well.
Yeah, absolutely.
If you're going to make it where it's here, and that's it. And just make it that way.
Yep. I agree fully. I'm going to step away for just a second. You can chat with the chat or talk more about yourself. I just have to hit the bathroom. I'll be right back. Turns out my wife is going to take care of all the driving, and she's such a gem. There was a meeting at the church for like the kids' activities, and I'm like, just send me an email. I don't want to go to your meeting. Like, you're just going to give me a piece of paper and then waste my time anyway. She's going to go there for me, so I don't have to like leave the stream and start a new one. We'll be able to just keep going. I just have to pee. So, chat with the chat, and here I'll enlarge you while that happens, and then I'll be right back.
I don't have the power to make some of these chats bigger, but there were a couple that I saw that I thought were I'm just going to look at you silently. Yep, that's what I'm going to do. I don't have any control. I can't make any comments any bigger or anything like that. So I can answer questions, I guess. But look up Jennifer Pritzker. Oh, is that Peanut Butter Pritzker's wife? Is Jennifer Pritzker? I heard somebody call him Peanut Butter Pritzker one time. So I was like, oh, that's hilarious. Oh God. Yeah, she's a dem or a gem. Yeah, more like a. Never mind. Oh, that's a. Okay. Balls or no balls? I don't get it. I mean, I don't know if Nick's seen this whole stream or not, but I listened to a lot of the second half. I didn't catch all of the stream, but listening to it, I think that it's going to be a question about whether I think it's. I don't think it's going to be a major majority. I think it's going to just probably be a 5-4. I think it's going to either be. I don't think it's going to be along the political lines. I think it's going to be a 5-4 majority of it. I don't think it's just going to be the question of. I think that several of the Democratic people, several of the Democratic judges, I think, are obviously going to be against Trump because they're anti-Trump no matter what. But I think that there may be. I think one of them might jump and over and make it either a. It's going to either be a 6-3 or a 5-4. I think on the ruling. I don't think it'd be anything other than that. No, I have not lived in my whole life in Arizona, although I've been here for more than half my life now. So I've been in Arizona since 2004.
Sorry, I got to get my headphones in. Okay.
They keep talking about balls or no balls. I have no idea what they're talking about.
Ignore them. Ignore them at all costs. They're a raucous bunch.
That's what I'm going to ask your friend on the other side of that question.
Let me point out then that there are two criteria. One is birth on the soil, and the other is allegiance or allegiance.
Real quick, I just want to say a big shout out to Robert Gouveia, who has rated the stream, and his viewers over on Rumble. Really appreciated. Glad to have you guys here.
Have is birth on the soil remains the same, right? And so they are, and that's why so much of Wong Kim Ark is actually we agree with, because they are adopting a modified British rule. They are not going the French rule, that Vattel talks about, where it's like who's the citizen. That had to be done by statute, as you pointed out, which it was in 1401. But what they've got is they say birth in the United States and subject to the jurisdiction thereof. That is talked about as allegiance, allegiance, allegiance in the congressional debates, but they were clearly not incorporating the British feudal monarchical conception of allegiance where it's indefeasible. I mean, going back to the early 1700s, our nation had repudiated the notion that citizenship is indefeasible. The expatriation statutes for the late 1700s reflect that. And again, you look at the 1868 congressional report that we cite there, this is the same group of congressmen, Republican congressmen, and they say things like the U.S. Constitution itself is proof that Blackstone's theory of allegiance was not accepted. So they accept birth on U.S. soil, but then they take the concept of allegiance and give it its Republican, Democratic, American understanding. And that's very, very, I think that makes a ton of sense.
Okay, and let's talk about its applications. So, there are some, I can imagine it being messy in some applications. So what would you do with what the common law called foundlings? The thing about this is then you have to adjudicate if you're looking at parents, and if you're looking at parents' domicile, then you have to adjudicate both residence and intent to stay. What if you don't know who the parents are?
I think there are marginal cases. That one, I think, has the benefit of being addressed in 1401F, where it talks about.
Yeah. But what about the Constitution?
Under the Constitution, it's I mean, look, domicile is a constitutional standard in all kinds of other situations.
Well, and it's hard.
Diversity jurisdiction, personal jurisdiction, sorry.
Well, yeah, and personal jurisdiction, 1332, diversity jurisdiction. And the thing is, it has to be litigated because it turns on intent. And the virtue of both jus soli and jus sanguinis, whichever one you pick, it's a bright line rule. How would it work? How would you adjudicate these cases? You're not going to know at the time of birth for some people whether they have the intent to stay or not, including U.S. citizens, by the way. I mean, what if you have someone who is living in Norway with their husband and family, but is still a U.S. citizen, comes home and has her child here and goes back? How do we know whether the child is a U.S. citizen because the parent didn't have an intent to stay?
I'd say make 2 points, one practical, one legal. The practical point is under the terms of this executive order, you don't have to because the executive order turns on objectively verifiable things, which is immigration status. Are you lawfully present but temporarily present, or do you have an illegal status? So those kind of taking evidence, so to speak, under subjective intent wouldn't be done. And as to the constitutional point, obviously domicile is baked into a lot of constitutional and legal concepts, and there may be situations where facts are determined, but if you look at the guidance that all the agencies did after this court in Casa said the agency could go forward and issue guidance, the guidance provides, I think, very, very clear, objective, verifiable approaches to doing this. And so as a practical matter, I don't think it's presented by this executive order.
Thank you, General.
Justice Jackson?
Good morning, General. So I guess I am looking at your position in this case, and it boils down to...
Oh, great.
It boils down to...
The last thing this chick boiled was chicken. God, I hate her. She is so terrible at being a Supreme Court justice. I need to stop calling them dumb. Like, they have to have some level of intelligence, I guess, to get to where they got. Smarter than me, I assume. But the I don't know what it is. I don't know what to call them. It's shocking how...
We all know she was a DEI hire.
Yeah, she was... That's not even an insult. That's Joe Biden's own words.
Right.
I just need her to be black and a female.
Just like his VP choice that he had. So, yeah.
Yeah. In fact,
I just need you to be black and a female.
that man's such a hero. Okay, back to it. God, I'm so looking forward to what she has to say.
requiring us to do at least these two things. One is believe that the framers were not importing the common law rule and understanding of birthright citizenship. And the second is
there isn't a common law rule and understanding of birthright citizenship. It's not a thing that existed yet.
and you'll see that's what she says so many times throughout this is she just keeps referring to a common law ruling of it. And it's like, there's not one. If there was one, then it would have been implemented into, or it would have been addressed whenever they wrote the 14th Amendment. And it wasn't because it didn't exist.
Yeah, like this is immediately I can't stand this woman. Like,
is to believe that what they were doing was departing from that common law rule in the way that you suggest. That is, they were seeking to have this turn on domicile. I think you have a number of hurdles to accomplish those two things. One of which, I think, is that when we look at this court's case law, and no one, I think, has mentioned Schooner's Exchange, but it appears that that was an 1812 case in which it seems as though the court had already accepted at the time of the ratification of the 14th Amendment that the allegiance that you were talking about was the English common law rule. That, in other words, allegiance meant that you are covered by the laws of the jurisdiction, that you can rely on that jurisdiction's protection. That's what allegiance meant. Now, you're saying today, no, allegiance meant something about loyalty or that kind of idea.
She's so stupid. She's so dumb. It's like, yeah, that's what he's been describing as under the jurisdiction thereof. Like, that's the entire point. That allegiance is directly tied to the protection of the state. She's sitting here acting like this is contradictory, but it's perfectly supportive of what he said. But she doesn't understand that. She literally doesn't get it. And it's wild to notice that this is 1/9 of our judicial authority being exercised, and just doesn't understand the basic question.
Well, and the fact that she's referring to an 1812 case of, involving a ship. What does that have to do with anything of what they're? I mean, it doesn't make any sense that she keeps bringing up, was it schooner exchange or whatever, schooner exchange or whatever. It's like, how does that apply? And again, it's her keep going back to this common law.
Let's see, Schooners Exchange versus McFadden. Let me just see real quick. So, very delicate import, an important inquiry whether an American citizen can assert in an American court a title to an armed national vessel.
Yeah, because they took over a ship. It was like a foreign warship that was exempt from jurisdiction because they seized the vessel, which was formerly theirs, but had been converted into a French warship.
Sure, yeah. A public vessel of war of a foreign sovereign at peace with the United States coming into our ports and demeaning herself in a friendly manner is exempt from the jurisdiction of the country. Exactly. You cannot create jurisdiction without the sovereign's consent. And that is the fundamental issue. Wong Kim Ark subverts the sovereign's right to refuse. And that's silly. That is a dumb prospect, because that was not the intent. It's the opposite of intent. I don't know what else to say. It's the literal opposite of what's intended by both the 14th Amendment and Article 1, Section 8 to do it this way. Congress can just write this law. They could write this law tomorrow. And that's not a problem, but they haven't written that law, and they know they won't.
And they can write this law and introduce it tomorrow and make all of this moot, because it doesn't matter, because even if the Supreme Court rules on one side or the other, Congress has already jumped the shark on it.
Right. And I think a lot of people don't realize that Congress can do that on almost any subject that exists, that any, outside of fundamental Bill of Rights issues, where Congress would be writing a law restricting a fundamental right. Outside of that, Congress can rectify basically every Supreme Court decision before the Supreme Court even decides it. They could moot the case immediately if they could just get off their asses and pass a law that addresses it. But the problem is these things go to the Supreme Court for lawmaking because they can't get it through Congress. And there's no way birthright citizenship would have passed. The idea that they would have done this in 1866 is insane. we were still nationalistic back then. We were, we had national pride. We did have a healthy distrust of other nations, and we recognized international, the international rules of warfare, of conquest, of property, of sovereignty, and we did it in a way that was overt and obvious. Fuck, we fought a war to establish it specifically. The idea that a mere 80 years later, that they would completely reverse course and be like, you know what, actually our sovereignty doesn't matter, and it's in the hands of whatever loser comes into our country and just decides to take it, is ludicrous. It's only conceivable really now that might pass, and it still wouldn't, because if they could pass this, they would have done it already, but they know they could never get this through in a statute.
Yeah, and they never could get it through on the without blowing up the filibuster either, because even if it was the case, they're not getting a supermajority through the Senate.
Yeah, they would have to blow up the filibuster, and they would have to force Democrats to take a wildly unpopular position.
Oh yeah, I mean that's not far past what our Democrat leadership does right now, anyways. But
Right, but they don't like to put their names on it. They don't like to stamp it with their political clout or capital, because Even Democrats don't like the idea that someone can come in and take citizenship. It cheapens and demeans what citizenship is. We're not even allowed to have national pride because our national pride is sold away from us by rulings like Wong Kim Ark.
But if the Supreme Court had, prior to the 14th Amendment, established that allegiance meant the common law definition, I think your first hurdle is to help us understand why we would believe that when the 14th Amendment was ratified, the framers weren't just incorporating what we had previously said it meant.
Page 572 of the congressional record directly addresses this. They say the concept of temporary and local allegiance from the Schooner Exchange is what is meant by, or temporary and local jurisdiction from the Schooner Exchange is what is meant by the word jurisdiction in the 14th Amendment. Senator Trumbull says, I thought about saying owing allegiance, but again, quote, there's a sort of allegiance from persons temporarily resident in the United States whom we have no right to make citizens. So he expressly and consciously rejected reliance on SCOTUS.
What do we do with, I mean, that's a debate, and it's a discussion, very valid, but then we have a subsequent debate between Fessenden and Wade, where the same concept comes up, and it becomes clear, at least from Senator Wade's perspective, that that's wrong. So Fessenden, and I'm not sure whether these are senators, I apologize. Fessenden says, suppose a person is born here of parents from
You're going to bring up a congressional argument over this, and you're not even sure who you're talking about? Like, you didn't do the basic research, or more appropriately, your clerk didn't do the basic research? Like, is it a senator? Is it a congressman? Is it someone else? What do we know about this person? Like, you could find out, but she doesn't. And you're deciding this for the nation, and your decision is going to be a century-long standing at least, no matter what. And you don't even take you're gonna bring this question, and these guys have all this prep time to write these questions. Their questions are intentional, and they're about their own misgivings in one way or another about what they're going to write in their opinion. And she doesn't even know, and she doesn't do the work. God, I hate her.
That's because her ChatGPT didn't tell her what it was whenever she was doing it. So she only gives out what it spits out. Yeah, her clerk is also a DEI hire. There you go. Yeah.
If you stood in front of an appellate court in Arizona and didn't know whether the guy who you're citing on the congressional record is a congressman or a senator or something else, they would excoriate you. Like, they'd flay you in front. Like, they'd be like, how do you not know this? Like, you can't even tell us? This is your issue.
Absolutely.
And it's insane to think that this woman is in charge of so much. Julie says Kagan looks like J.B. Pritzker's trans cousin. Look up Jennifer Pritzker.
I did that while you were on break. I regret doing that.
Oh my God. Maybe I'll do it in just a second. Here we go.
From abroad temporarily in this country. Wade responds, the senator says a person may be born here and not be a citizen. I know that is so in one instance, in the case of the children of foreign ministers who reside near the United States, et cetera, et cetera. So it appears as though in that exchange, at least Senator Wade believed that the English common law understanding of what it means to have allegiance, to be a temporary person on the soil, was what was being adopted.
Yeah, that exchange strongly supports us. If you look at it in context, Senator Wade has introduced a version that says only birth on U.S. soil and doesn't have any allegiance or jurisdictional element to it. And so Senator Fessenden stands up and says, well, that can't be right because, obviously, what about the children of temporary visitors? It has this, it's another one of these statements that has this appeal to a background understanding that we all agree that the temporary visitors, their children do not become citizens. And then Senator Wade has to kind of backtrack and say, well, what about children of ambassadors? And in the end, Congress does not adopt Senator Wade's proposal. So we think that to the extent you can draw an inference from that, the inference strongly supports.
All right, well, let me just ask you about why we wouldn't see in the 14th Amendment anything about parental allegiance. Several of my colleagues have talked about the fact that your view of this turns on what the status of the.
Because there isn't a distinction between parental and child allegiance. It's a concept that, again, is completely non-existent. It's not just foreign to them. It's not within the realm of reality. It doesn't exist. So when they talk about children's allegiance, they're talking necessarily about the parental allegiance, because the children do not have a capacity to renounce citizenship and adopt a new citizenship. Even today, they can't do it. They need a guardian to do that. So the idea that they're talking about a child's alliance or allegiance is necessarily derivative of the parents, because it can't come from anywhere else until Wong Kim Ark.
Right. Like, it just, again, she, like I said, she keeps going back to the same well, even though that well is empty. Like, she just, there's no common law. So I don't know where she's even coming from such a position. And again, and there was one thing she said, I think she said that, oh, you're going back to this one instance. It's more than one instance. And that one instance that you're talking about really isn't applicable, because that was somebody that they were near the jurisdiction. They weren't on American soil.
Right. I don't know. I don't know how she's allowed to walk into the building, honestly. Billdozer74 says KBJ is both a mental and physical midget. I agree.
Parents are, and not the child, as would the born in the United States view of it. Can you help us understand why we wouldn't expect to see a mention of parents in the text of this amendment?
I think it was well understood that, for example, children cannot, newborns cannot form domicile. So it follows every 19th century.
That assumes domicile is in the test. And I'm asking you, how do we know that Congress did adopt the test that you say it adopted?
When you're looking at 19th century conceptions of allegiance, the notion that the allegiance, again, we say domicile is instantiating the concept of allegiance for aliens.
They literally, like, he's covered this, I think, 4 times so far in his argument. The guy who wrote it said exactly this. He said exactly this, that allegiance, domicile is a lack of allegiance to any other, authority. That's what jurisdiction was. Sorry.
I think all of the lefties on the Supreme Court are all trying to get him to like trip over himself, and he's stood firm. And every time that he said it, he's like, "Look, here's the exact words. How many times do you want me to say this? I'll say it to all 9 of you if I need to. Here's the exact words."
If he had a more complicated approach, or a less fleshed out approach, it would maybe be tough. Like, it can be hard fielding all these questions that are similarly worded, but might have 1 or 2 things, critical word changes that can change whatever. But his answers are they're so foundationally rooted in his core argument, and the core argument is so simple that he's not going to get tripped up on this. He's an exceptionally accomplished lawyer as Solicitor General of the United States, and this is what he does. Like, he makes these arguments before this court all the time. So he's practiced at the Supreme Court in a way that most lawyers will never have the opportunity to be.
It's like one of these like appeals that you write a briefing for, is that you submit to the court, where it's like, I feel like I'm literally just copying and pasting the same like paragraph in each section, because this is the rule. This is how it's tailored down to this nuance right here. Just fit it in everywhere. It's going to fit.
Yeah.
Opposed to citizen, all of that, the 19th century understands the newborn's domicile, its allegiance follows the allegiance of the parents. And I point out that their theory relies on parental allegiance as well, because they recognize the exceptions for, hostile invading armies, for tribal Indians, for ambassadors. Again, the child's allegiance status, even on their view, turns on the status of the parent.
What do we do with?
Yeah, I mean, the insanity is that under the current understanding, a hostile invading army at war with our nation could have a female unit deliver babies and they become citizens of the United States. Like, that's retarded. There's no other way. Like, what are we doing? That can't possibly be the intended outcome, especially in 1868, I think was the 14th.
Professor Mueller's amicus brief and the historical record and the fact that even at times in this country where we understood that the parents were declared enemies of the United States, I'm talking about World War II and Japanese internment, babies born in that circumstance were given birthright citizenship. So it seems as though this concept of allegiance of the parents really wasn't driving birthright citizenship, at least at this period of our history. So are you saying this is...
Yeah, Calamity Sue, I understand that is what's happening. Like, I get that. I'm just saying that at the time it was written, there's no way. There's no way. At the time it's written, they wouldn't have wanted a Southern baby, a Confederate baby born in the Union, to be a Union citizen. They would not have wanted that. You know, obviously the 14th came after the war and the Reconstruction era, so that had been reconciled and the Confederacy no longer existed. But if you had just, you know, accelerated it by 5 years or something like that, they would have never thought conceptually that was correct. They wouldn't want that, and there's no way they would have wanted a Mexican baby. Right? And which is funny because that's what we're primarily talking about. But there's no way that Texas would have allowed a Mexican baby born in Texas to be a Texas and therefore a U.S. citizen. It's
definitely not in the 1800s.
Yeah.
Wrong, or they shouldn't have gotten birthright citizenship?
Well, if they were domiciled here, yes, they should have. If they were temporarily present, then no. But the executive practice we can see from the 1930s.
How does the temporary presence run with your concept of allegiance? I'm not sure I understand. So can you be clear? Are you saying that only people who are domiciled here is...
Nick, what if an escaped slave gave birth on Union land? Unquestionably, both of them still belong to the slave owner.
Yep.
And that Dred Scott doesn't address that directly, but Dred Scott addresses a very close type of issue. And Dred Scott, the ownership of a slave of Dred Scott himself, which was here in Minnesota at the fort, Fort Snelling. It was like the general who is in charge of Fort Snelling. He owned the slave, even though that was illegal in Minnesota. And then, he moved and Dred Scott escaped or something. I can't remember the exact thing, but they determined that even though the ownership of Dred Scott was illegal, he was still considered property, and they returned him back to slavery, or his wife or whoever it was I think it was him.
I think it was Missouri, not Minnesota, but they went into Wisconsin where slavery was illegal. And then whenever they brought him back, he sued for his freedom because it was illegal when they went to Wisconsin. But they still said, no, you're still property. But I think it was Missouri, not Minnesota. But I mean, I will defer to...
I think they went to Missouri. Is where you're correct, but I think that let's see, lived in Illinois and the Wisconsin territory. Why did there's must be a similar case that involved, because I remember one of them involved Minnesota and Fort Snelling very specifically. But yeah, you're right. It's Missouri and Wisconsin. Which case was that? I'll find it.
You define it. Can
form
the necessary loyalty to the...
As an Army officer, Emerson moved frequently, taking Scott with him to each new Army posting in 1833. Emerson and Scott went to Fort Armstrong in the Free State of Illinois. In 1837, Emerson took Scott to Fort Snelling in what is now the state of Minnesota and was then the Free Territory of Wisconsin. So that's where the confusion came in, because you said
back then it was Wisconsin and
right.
it hadn't become Minnesota yet.
Right. Now Fort Snelling is right by the airport in the Minneapolis airport. So, okay. So I was like, I know that I'm not wrong on this, but it's saying I was wrong, but I had to read further.
United States?
It's not allegiance is not a question of subjective loyalty.
Okay.
Oh, it is something you owe. It's a reciprocal relationship between the citizen, whether they want it or not, they have that allegiance. And I think it's powerfully.
On the basis of what?
Domicile. I mean, that's what it says in so many words in the Venus and the Pizarro. It says, look, if you're talking about an alien, if they're just temporarily passing through, no, they don't have allegiance. But if they've made it their permanent home, they become part of our political community, and they are analogous or akin to citizens.
All right, just quickly, because
Yeah, the sovereign's protection and the sovereign's enforcement of law, and specifically what a lot of people don't realize is all of this is derived from the common law understanding of property rights and the enforcing of property rights. And that enforcement of property rights is a primary function of government, because property rights include your rights over your own body, your own autonomy. And so this concept that he just laid out is the whole thing. It's a reciprocal agreement and an arrangement. I will offer you the protection of the sovereign, the ability to operate under the laws that we have established and the rules that we've established, and we will protect you under those rules. But you owe us. That's what selective service, or outside of selective service, conscription was all about. Like, at some point, you may be called in to serve and protect the sovereign that has protected you through the legal system that you have chosen to domicile yourself under. That's the whole point of it. And again, why he's having to answer these basic questions about how this functions is beyond me.
Well, and the fact that he is answering them, and he's answering them clear, so then she's having to pivot away from that point to try and pivot to another point. Like, she's trying to catch him in a gotcha game, and he's able to duck and dodge everything that she's throwing at him, and so she's just trying to, okay, well, then I'll go on to my next point that I'm going to try and catch you in.
Yeah, it's almost it's kind of insulting.
because I'm mindful of the time. What do you do with Won Kim Ark's statement that birthright citizenship is applying, quote, independently of a residence with intention to continue such residence, independently of any domiciliation? I know that they use domicile, it's a fact in the case, but that's not a part of their holding. It's not what the reasoning turns on. Correct?
I believe you're quoting from page 693 of that opinion. It goes on to say, not citizen terms on that, but the duty of obedience to our laws. It doesn't take the further step at that point and say, therefore, if you have temporary and local allegiance, you're a citizen. And immediately before that, you have that page 693 summary of the court's holding, where it says
You say
domicile.
Won Kim Ark incorporates a domicile requirement.
That is the holding. It's definitely clearly expressed in the holding.
All right, one final thing, perspective. You say
That is the
perspective,
holding.
we're supposed to do
well,
this.
then one
Don't
final
worry
thing.
about the people who are already here and who would not qualify under your rule. How does this work? Are you suggesting that when a baby is born, people have to have documents, present documents? Is this happening in the delivery room? How are we determining when or whether a newborn child is a citizen of the United States under your rule?
And I think that's directly addressed in the SSA guidance that's cited in our brief. What SSA says is there's currently a system where, for example, social security numbers are generated based on the birth certificate. They say this can still be, for the vast majority of instances, completely transparent. You will still get a...
No, not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So are we bringing pregnant women in for depositions? What are we doing to figure this out?
No, as I pointed out earlier, the executive order turns on lawfulness of status. So if you give birth to a baby in the hospital right now, it gets the birth certificate in the system. There's a computer system.
So there's no opportunity, there's apparently no opportunity then for the person to prove or to say that they actually intended to stay in the United States?
Absolutely not. The opposite is true. Their opportunity to dispute if they think they were wrongly denied, which would only happen in a tiny minority of cases,
After the
is
fact.
directly addressed in that guidance.
After the fact,
Yes.
after their
Yeah.
baby has been denied citizenship, then we can go through the process.
And the way that, I mean, I'm summarizing because I'm not an expert in
Yes.
computers, but there's a computer program that currently automatically generates a social security number. SSA says, look, a social security number, non-citizens can have them if they have work authorization, so it doesn't prove citizenship. We'll give you a social security number, provided that the system automatically checks the immigration status of the parents, which there are robust databases for, and then it appears no different to the vast majority of birthing parents.
Thank you.
Thank you, counsel.
This should be good.
Ms. Wong?
Mr. Chief Justice, and may it please the court.
Oh my God, I'm gonna lose my shit.
Something wrong.
Cecilia Wang, ACLU National Legal Director. God, this is a person that I would have trouble being in the same room with. Like I would get myself yelled at by somebody.
Ask any American what our citizenship rule is, and they'll tell you, everyone born here is a citizen alike. That rule was enshrined in the 14th Amendment to put it out of the reach of any government official to destroy. When the government tried to strip Mr. Wong Kim Ark's citizenship on largely the same grounds they raised today, this court said no. 30 years after ratification, this court held that the 14th Amendment embodies the English common law rule. Virtually everyone born on U.S. soil is subject to its jurisdiction and is a citizen. It excludes only those cloaked with a fiction of extraterritoriality because they are subject to another sovereign's jurisdiction, even when they're in the United States. A closed set of exceptions to an otherwise universal rule. My friend has now clearly said that the government is not asking you to overrule Wong Kim Ark. That is a fatal concession, because Wong Kim Ark's controlling rule of decision precludes their parental domicile requirement. The dissent understood that, and the majority tells us 6 times in the opinion that domicile is irrelevant under common law. Lynch versus Clark was already the dominant American case on citizenship, and it held that the US-born daughter of temporary visitors from Ireland who took the baby back to Ireland with them, that daughter was a US citizen. Authorities, including Lincoln's Attorney General and Kent's commentaries, embraced Lynch, and Kent specifically talked about temporary sojourners' children being US citizens. Justice Field said in 1884 that reflected the general understanding. That understanding was confirmed by Congress with its 1940 Act. The 14th Amendment's fixed, bright-line rule has contributed to the growth and thriving of our nation. It comes from text and history. It is workable, and it prevents manipulation. The executive order fails on all those counts. Swaths of American laws would be rendered senseless. Thousands of American babies will immediately lose their citizenship. And if you credit the government's theory, the citizenship of millions of Americans, past, present, and future, could be called into question. All of this tells us the government's theory is wrong. I welcome the court's questions.
There are 5 exceptions to citizenship that you do accept.
Yes, depending on how many you count, Justice Thomas, how you count them.
What is the
Numerically.
underlying rule of law that you use to connect these 5 exceptions?
Sure. So as I just said, all of the exceptions involve situations where that US-born child is not subject to the jurisdiction of the United States because that extraterritoriality, that fiction of extraterritoriality, the interaction of another sovereign between the United States' jurisdiction and that person applies to the child as well as to the parent. Everyone else born in the United States is subject to the United States' jurisdiction. To answer Justice Barrett's question to my friend, that's what sets those exceptions apart from other US-born persons.
He ain't your friend.
We've heard a lot of talk about Wong Kim Ark, and you dismissed
God bless you, whoever
the
sneezed
use
in
of
the courtroom.
the word domicile in it. It appears in the opinion 20 different times.
Probably Trump sneezing.
And
bullshit.
including in the question presented and in the actual legal holding. And the government doesn't want it to be overruled because it's willing to rely on that particular fact in that case. Isn't it at least something to be concerned about, to say that since it's discussed 20 different times and has that significant role in the opinion that you can just dismiss it as irrelevant?
Well, Mr. Chief Justice, I think we have to look at what the controlling rule of decision is in Wong Kim Ark.
That was an okay question by
takes
Robert,
pains
sir.
in the majority opinion to set out his analysis. He first starts with a premise that in construing the 14th Amendment Citizenship Clause, we look to the English common law. That was the rule that applied from the colonial era on, at least for the colonists and for European immigrants. He then says, look, Chief Justice Marshall tells us in the Schooner Exchange what subject to the jurisdiction means, again looking to the English common law. Under English common law, if you are born in the dominions of the sovereign, you owe natural allegiance, and those who are present in the dominions of the sovereign owe temporary allegiance for as long as they're present. The only exceptions, again, at common law were ambassadors, people born on foreign ships, and people who were born during periods of foreign occupation. He then gets to the government's favorite page, 690.
But that would be because the sovereign chooses to exercise that jurisdiction.
Right.
That was the sovereign's decision to do that. But the entire idea of sovereignty is that the sovereign cannot be bound by the sovereign decisions of another entity. So it's like, that's what sovereignty means. It's crazy. I'm
3, where he says, look, we have had this rule in the United States as to citizenship, at least for white Americans, from before independence. The purpose of the 14th Amendment was to embrace that universal rule of birthright citizenship, to embrace and incorporate the common law exceptions with the single additional exception of the pre-existing exception for tribal Indians that we had in the United States, which is an analogous exception, and that's the closed set of exceptions. You can't make sense of the holding in the case without looking to the controlling rule of decision, which is the common law. And I think my friend agrees that under English common law, domicile was not relevant, and the children born to temporary visitors in the territory of the sovereign were always considered birthright citizens.
Well, Ms. Wong,
whoa, wait. I mean, she says, I think my friend agrees. He just argued the opposite of that.
Exact opposite.
That's
No,
this is a wild statement. I think he agrees with us. Nope. His entire position is contrary to that. And he expressly stated the opposite. What is happening in this courtroom?
That's because none of them are listening to what the generals actually said, and they're just trying to all put what they already have decided in their mind. So that's what she's doing too. She's being like, okay, you guys seem to have already decided this with me.
It's the same approach that they took in Roe versus Wade. They're like, well, this is what the rule is. Therefore, this is what the rule should be.
And you'll see, like I said, I've already seen all of her part, or I've already listened to it because I listened to it live. But at the very end, you'll see she's like, well, when you find for me and when you do this for me, when you agree with me, and I'm like, okay, you're projecting you're telling them what they're going to find. But, I don't think her arguments are very solid.
We'll see. So far, I'm not impressed.
I mean, everything you say strikes me as, yeah, that's the way I read it too. But then what are those 20?
And there you go. That's all the evidence you need in the world to know that it's wrong.
Yep.
Domicile words doing there? Like you can, take.
They didn't base this on domicile. But my question is, what are all these domicile words doing there? As Roberts pointed out, it's mentioned 22 times.
Yeah.
And they're like, but they weren't basing it on domicile. That's crazy.
Take some of them and say, they were just summarizing the facts of the case, but not all of them. And why did they keep on, why did they sprinkle that in the opinion?
Well, I think, again, those were the stipulated facts in the case. And it's clear we have textual evidence in the majority opinion that they were simply saying this is an a fortiori application of that controlling rule that comes from the English common law. Justice Gray writes, again, after setting out the English common law rule and the exceptions with the single additional exception for children of members of Indian tribes, that the amendment in clear words and manifest intent includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. And as was pointed out earlier, the very next part of that same paragraph, he cites to Webster talking about Thrasher's case. And he says, people who are born in this country owe allegiance independently of a residence within, foreign nationals owe allegiance independently of a residence with intention to continue such residence, independently of any domiciliation, and independently of taking any oath of allegiance, which is totally contrary to both the government's theory of dual allegiance or partial allegiance and to the theory of domiciliation.
I mean, I might agree with you if domicile had simply been sprinkled in the opinion, but in Wong Kim Ark, it's a long opinion, but it begins.
What was that?
He said, I would agree with you if domicile was sprinkled throughout the opinion. Yeah, 22 times is not sprinkled. That's a shower.
Yeah, that's... It's
raining domicile all over this opinion, all right? Like,
judicial opinions are bloated nowadays, but Wong Kim Ark wasn't a bloated opinion. They still wrote concisely back then. To have 22 mentions of anything in the precious real estate of a Supreme Court opinion is crazy. Like that means that it is a critical and core focus of the opinion. Or
they also
whatever.
had to make how many copies to disseminate all those copies, so they didn't want to have a super long opinion that they would have to copy multiple times.
Yeah, they didn't. Was the printing press even around? The printing press may have been out in 18.
It may have been out, but I don't think it was like very, very common.
By saying, here's the question, and it ends by coming back to the question. And it says, here's the question, stated at the beginning of the opinion, namely, whether a child born in the United States of parents of Chinese descent who at the time of his birth are subjects of the Emperor of China, but have a permanent domicile and residence in the United States and are there carrying on business, and he states the diplomatic exception, and he says, for the reasons above stated, this court is of the opinion that the question must be answered in the affirmative. So why put domicile in? Sometimes it's hard to figure out what is the holding of the case. Here he tells us this is the holding of the case. Why put domicile in there? It's just something, it's something irrelevant that he wanted to throw in. It's like, whether a child born in the United States of parents of Chinese descent who once resided at a particular address in San Francisco, who attempted to enter the country at the port of San Francisco. Why put it in if it's irrelevant?
Well, Justice Alito, I'll give you two responses. The first is that, again, it was a stipulated fact. The second is that regardless of what the judgment in the case was, which again was an a fortiori application of the rule of decision, the rule of decision in Wong Kim Ark has binding precedential effect. Even if you think that Wong Kim Ark decided the case based on the stipulated facts, you have to follow that controlling rule of decision. And if you follow that rule, you get to the same result for people without domicile. Wong Kim Ark says 6 times in the first parts of the opinion, as well as on the page the government focuses on, that domicile is not relevant.
Well, Ms. Wong, on that, what do we do with the fact that after Wong Kim Ark, at least some authorities took the view that the non-domiciliary question wasn't decided, remained open, and even continued to press the view that domicile is required? Now, I know you've got a lot of good stuff on your side too, but what do we do with the fact that many sound legal authorities thought it remained an open question, even if one of them wasn't John Marshall Harlan?
I liked your example from Justice Harlan's lecture here in DC. So here's what I would say. All of the government's citations in their
I
brief
missed the fact that she laughed at
generally
Gorsuch
either were
the first
rejected
time.
by Wong Kim Ark expressly if they
I'm talking
predated Wong Kim Ark.
post. If we're trying to understand how the legal community understood what happened in Wong Kim Ark,
Sure.
it seems to me it's a mess.
So-
maybe you can persuade me otherwise.
I think I can, Justice Gorsuch. First, as to the post-Wong Kim Ark authorities that the government cites, each one of them is inconsistent with Wong Kim Ark's reasoning or doesn't mention it at all. Most of them have very little reasoning at all. And in contrast, what we have on our side,
The decisions cited in Wong Kim Ark are incongruent with Wong Kim Ark itself. Yes, necessarily so, because again, Wong Kim Ark establishes something that doesn't exist. It just created it. So all of the stuff that they're citing in Wong Kim Ark would be the opposite. This isn't a mystery. This drives me insane.
Wong Kim Ark is numerous federal court decisions around the time of Wong Kim Ark, between ratification and Wong Kim Ark, that said that domicile is not relevant. They cited Lynch versus Clark, which again was about the daughter of temporary sojourners. We have the 6th edition of Kent, which was cited in Wong Kim Ark, and of course was then cited after Wong Kim Ark was decided by many authorities, again discussing temporary sojourners. Anyone who wanted to know what the law of citizenship was under the 14th Amendment after Wong Kim Ark would go to the 6th edition of Kent, where he says in that footnote on page 38 that the rule was Lynch versus Clark and temporary sojourners' children are U.S. citizens. We have members of Congress speaking on the record on debates on immigration laws, where they were finally passing these immigration restrictions that Senator Cowan wanted. And they all stated either that Lynch was the rule, that Attorney General Bates had stated the rule, again citing Lynch, or Kent, and stating the rule that everyone born in the U.S. is a citizen, and saying, look, children of Chinese immigrants, these immigrants who are unwelcome, these immigrants that Congress is now trying to bar from entering the United States, if their children born in the United States are citizens. We have in 1896, so a couple years before Wong Kim Ark, but in 1896 State Department regulation, which said the US-born children of foreign nationals are US citizens, accepting only the children of ambassadors. And then you have Marshall Woodworth, who is a US attorney who writes in a law review article that he's talking specifically about temporary sojourners' children, and he says,
okay, real quick, before she says whatever nonsense she's about to say, if your sentence says who writes, or it starts with who writes in a law review article, those are persuasive essays about what the author thinks the law should be. They are not always an accurate reflection of what the law is, but they are written in a way to make them, in the persuasive way of assumed authority and assumed correctness. And that is such a common thing. That's why law review articles are secondary or even tertiary authority, because they're so often slanted or biased. They're not reflective of a reality. They're reflective of the desired reality of the author based on their research, but oftentimes based on their presupposition and then proof texting.
Right. It's all based off of what position they want it to come out with. It's not based off of these are the facts and this is the unbiased opinion. It's definitely a biased opinion, so they're always going to lean one way, and that's why you're going to always find law review articles on both sides. And that's why in law school you have to have law review articles that you have to cite to, because you have to find some that are on your side in your opinion.
Absolutely.
I'm going to step away for just a second.
don't think-
Sounds good.
You can keep playing. Yeah, I've already heard all of her, so you can just keep playing.
Sounds good.
I think that's a good rule from a policy perspective, but that's the general rule.
Ms. Wang, can I
Yes.
offer a possible explanation for why Justice Gray made a point of putting domicile in what he said was the holding of the case. And it is this. Wong Kim Ark and his parents, had they come to the United States from Europe, could have been naturalized. But because they were Chinese, they could not be naturalized. And they had done everything that they could to make themselves Americans by establishing a domicile in the United States. And so that's what this was about. He couldn't get naturalized because of a racist law, but they had done everything they could to become part of the American society. At the same time, there were many, many men who were horribly exploited, brought to the United States to work on the Transcontinental Railroad, to work in mines. They were worked to death. They were treated horrifically, but they were not, they were overwhelmingly men. There wasn't an indication that they would stay here, they could stay here, they didn't have permanent homes. And the opinion is drawing a distinction between those two categories of people who would have been well understood at the time when Wong Kim Ark was decided.
No, Justice Alito, I don't think that's a plausible explanation for why domicile is mentioned in Wong Kim Ark, because again, the controlling rule of decision based on the English common law and cases from Schooner Exchange to Lynch versus Clark to State versus Manuel, which was the North Carolina decision that said, look, the rule in the United States from independence on has been the English common law rule. That explanation would be inconsistent.
But Ms. Wong,
yes.
isn't that explanation, I take Justice Alito's point, and I think he actually makes a good one in the sense that it could be that Justice Gray emphasized domicile to help the public accept the outcome of this case. You're suggesting that the emphasis on domicile was not a part of the rule, meaning he wasn't saying you had to be like a foreigner who is doing everything they can and who can't be naturalized, but he might have emphasized those facts in this case precisely because Chinese immigrants were unwanted, precisely because he had to get this out into the public and people were going to say, whoa, you're saying these people have to, this baby has to be a citizen? And so one could imagine that it was important from a standpoint of helping people accept this citizen rule under these circumstances to emphasize that these particular people in this case were in Justice Alito's first category.
I think that is very possible, Justice Jackson, and as evidence of that, I would point to the fact that if you look at the briefing in Wong Kim Ark, you'll see that even though the parties had stipulated in the district court that Wong Kim Ark's parents were domiciled in the United States, when the case came to the Supreme Court, the government's brief argued that it was impossible for Chinese immigrants to have domicile because they expressed the view that was common among people who opposed immigration by Chinese nationals to the United States. There was a common view that Chinese people were inherently temporary sojourners in the country. And so I do think it's possible, Justice Alito and Justice Jackson, that he was trying to dispel that notion and tell the government.
Absolutely, that at least it reads as though he's trying to calm everyone down. These particular people were domiciled, but we're following the English common law rule. And when you look at the English common law rule, domicile is not a factor.
That's right. I think, you know, who knows why the majority opinion mentioned domicile. We know is a stipulated fact. We know the government tried to renege on that stipulation and rely on this assumption on the part of anti-Chinese advocates at that time that Chinese people couldn't form a domicile in the United States, and he followed the English common law rule.
Ms. White, can I move? Oh. Go ahead. I just wanted to ask you a question about how the exceptions fit within the general rule. You've called them exceptions, and some of the common law sources call them exceptions, so I take that point. But if we think of use solely as tied to the territory, and we look at the exceptions as territorial in a sense, then they seem kind of like natural outgrowths of that rule, and this is what I mean, and this is where I want your help with how the exceptions played out in practice. If you look at Indian reservations as unique places because Indians were quasi-sovereigns, separate nations in the American system, if you look at occupied alien territory as territory that's outside the jurisdiction of the United States, and then if you look at the diplomatic exception, almost like diplomats and their children had little bubbles around them, like the embassy is really the territory of that country, and even when they're traveling around, they're all not subject to the jurisdiction by virtue of this territorial fiction. Are those just applications of the rule? And if they are, then what happens to alien enemies like the German spies in Ex parte Quirin, or what happens to Indians who are actually not on the reservation but may be born, say, in Baton Rouge? How does the rule apply in those situations? Does it travel with the person, or is it tied in some sense to the land?
Sure. So let me answer each part in turn. So the thing that all of the exceptions have in common, again, is this sense that the person has this fiction of extraterritoriality around them. Let's set aside the Indian tribal exception for a moment and come back to it. So the example of enemy aliens, for example, ex parte Quirin, is one that is answered by Justice Story in both Inglis and in Rice. And the touchstone under the American application of English common law was that in wartime, the touchstone is whether there's a foreign occupation of U.S. territory. So,
and that's, just to interrupt for 1 second to
Sure.
clarify, and that is territorial. Sometimes it just seemed to me that the rule varied. Sometimes it was stated as enemy alien, and sometimes it was focused on occupied territory.
Sure. So the rule, I don't think there's a separate rule for enemy aliens, and the government's briefs describe the exception as an enemy alien exception. I don't think that is the best way to think about it. Rice and English tell you that when the British forces are occupying Castine, Maine, no one is subject to U.S. jurisdiction there because Britain is governing Castine, Maine. And Justice Story explains, look, if the U.S. then retakes that territory, babies who are born to U.S. citizens by what he calls post limine become U.S. citizens. So that's the way to think about any wartime situation, enemy aliens or otherwise. As we heard earlier, Professor Muller's amicus brief tells us how we've thought about enemy aliens in wartime. Even in World War II, when the United States was detaining Japanese nationals who were deemed enemy aliens of the United States, when those enemy aliens had babies in these detention camps, everyone agreed that those babies were U.S. citizens. And Professor Muller goes on to explain that there are many cases of those U.S. citizens going on to a lifetime of government service to the United States. Everyone agrees those babies are U.S. citizens like everyone else. So again, the touchstone for enemy aliens is.
So what about Indians? What about the Indian who's off the reservation or born off of a reservation?
Sure. So to start with the basics, I'll refer to the Indian tribal exception just to use the term of art. The Indian tribal exception, Elk versus Wilkins tells us, comes from the constitutionally unique status of Indian tribes. In the Indian Commerce Clause, we know that tribes are treated as basically quasi-sovereign nations. We know that from the Marshall Trilogy of cases. We know from Worcester versus Georgia, where Chief Justice Marshall said that the tribes are essentially a distinct political community.
Well, I understand all that. So just in the interest of time, just to focus you, I understand why the Indians are treated differently for purposes of the law, but I want to know, is it tied to territory or is it tied to the status of someone as a member of a tribe? Because if you're looking at it because of the special relationship of Indians to the United States as a matter of the Constitution, et cetera, well, I mean, citizens of France are citizens of a different sovereign as well.
Sure. So Elk versus Wilkins doesn't really answer that question. The court says there are two ways to look at this. Either you look at it as the tribal member is like an ambassador, or you can look at it like there's a territoriality issue where people are born on tribal lands, and therefore they're essentially, I think he says, Justice Gray says at one point, we might as well be talking about someone who's born in Mexico.
Well, there's a lot in elk, and some of it's not terribly helpful for you, it seems to me, because Justice Gray,
You think?
again, strikes again, says that they may be subject in some degree or respect to the United States. So
And this
some
is why I was
jurisdiction-
saying
he
it's
says
hard
they're
to
formal
read
in
on
the
how
geographic limits. They are
they're leaning on
in a
it.
geographical sense born in the United States. But because they are not completely subject to the jurisdiction of the United States and owe allegiance distinct from the United States, that's what takes them outside. And that language sure sounds a lot like the Solicitor General's presentation today.
To the contrary, Justice Gorsuch, I embrace that part of Elk versus Wilkins' holding. Justice Gray, of course, wrote both Wong Kim Ark.
I know, and it's a struggle.
Sure. Let me try to help you out with that. You know, the government tries to make it seem as though what sets the exceptions apart, what defines the exceptions,
She's
is that
tripping
the
over her
government
wang.
has some maximum theoretical power.
She's tripping over her monosyllabic word. How do you stumble through the?
She wants you all to see her wang.
She knows that what she's about to say is bullshit. That's the funny thing there. And Gorsuch, which he's asking retarded questions earlier, but maybe he was pulling the rope-a-dope where he's like, I just want you to explain this over and over for the chat, basically. But I'm not convinced that that's what was happening yet. But he has again, going back to the same question that all the justices seem to be asking her. You keep saying that it has nothing to do with domicile. Why the hell is it in there so much?
Right.
Why is that? And we go to this other case that the same justice penned, and it's the same themes that you're ignoring. Like, you're ignoring these things. Help us out with that. And she's like, let me help you with the issue. Okay.
And right, and think about the fact that, okay, if we were, you know, if you're trying to establish something of whether or not a court has jurisdiction over somebody, it's all about whether or not what's their domicile. Because you get people that are in the military that their domicile doesn't change even though they're stationed in another state, you know, so a domicile is relevant, and it is what this whole thing hinges on. If your domicile is not in the United States for the parents, then why in the hell should the domicile for the child be in the United States?
Right. And in a way, this harkens back to basic civil procedure questions of jurisdiction, going to international shoe and the creation effectively of long arm statutes for each state, saying this is how we exercise jurisdiction. This is how the sovereign state of whichever one it is has determined that it will exercise jurisdiction, and each state has its own authority to do so. And this is where the entire argument of the non-government breaks down, because they're ignoring that in every other capacity, every other one, the state or the federal state have the authority to choose and they're autonomously the extent of their jurisdiction and when they exercise it. But they're saying that in this case, none of them do. They're all bound to the decision, again, of an interloper, which is wild. And I think their English common law reference was incorrect. They're misinterpreting what was going on there by saying that even a temporary traveler was bound to whatchamacallit, not authority. It was bound to allegiance. It was bound to allegiance with the state that they were going through. It's like, well, yes, you were bound to allegiance by the king. That was him exercising his sovereignty. If you could choose not to give your allegiance, I don't think it'll go the way you want it to. In that instance, you can't choose to not give allegiance to the king and expect the protection of the king, and the unrequested or ungiven permission to go through his territory. That's what she's missing about the English common law there. It's like you have a duty to provide it because the king is going to provide you protection on the road through their territory. No, the king or lord or whoever it is, the ruler of that, that fiefdom.
The government could have exercised plenary regulatory power over the tribes, and therefore that's the same situation as a foreign national in the United States. But that's actually not true, because remember, if there's always this background notion, whatever the parameters of the relationship between the United States government and tribal nations at that time of ratification, there was this constitutionally distinct status of the tribes and tribal members, setting them excluding from apportionment, which was renewed in the 14th Amendment. And that's not true of foreign nationals. If the government were right that the question is what's the maximum theoretical power the government has, there'd be no ambassador exception, because of course the United States could decide in some instance to go ahead and prosecute an ambassador. There would be inter-sovereign comity considerations there. That's how you define.
You can prosecute an ambassador if their activities are outside of their ambassador duties, then they enter the jurisdiction of the United States. I know we talk about diplomatic immunity, but if a foreign diplomat pulls out a gun and shoots someone on the street, we can prosecute them. Now, that may cause an international incident, and we may not want to prosecute them, but that's entirely at the discretion of the United States.
Absolutely.
A state government cannot prosecute an ambassador for murder because of federal supremacy. But the federal government absolutely can say, oh, no, your ambassador status is revoked because you murdered a United States citizen.
Right. And it goes back to that. I think she's thinking more along the lines of what happened a couple of days ago with the No Kings rally. She's thinking about the whole kingdom and that, the left's belief that Trump's a king. So, But no, I agree 100%. She can't, you can prosecute a diplomat if they have gone outside of that. That's why all these law shows that they show, they've got diplomatic immunity. Not for committing murder, you don't.
Right. You have diplomatic immunity from state prosecution.
Right. Not from federal.
So long as the federal government chooses to extend that diplomatic immunity, they can actually revoke it. The whole thing, though, is that is a decision that has to be made by the executive, because the executive is the sole organ of foreign relations. And revoking the ambassador status of a foreign agent might cause an international conflict that goes against the aims of the United States. But again, the idea of sovereignty is critical here. The federal government is entirely in control of that decision, because they are the ones who are going to determine whether the consequences are if the juice is worth the squeeze on that one, and it's going to depend on the foreign nation. If a Cote d'Ivoire ambassador kills someone, that's going to be a different question than if a French ambassador kills someone. Or a Canadian ambassador, for example, because we have different, relationships with those countries than we do with the Ivory Coast. So, sorry, I said Cote d'Ivoire. I don't know why I went French on it, but.
In the exceptions. And as Wong Kim Ark says, Elk versus Wilkins has no bearing on the question of foreign nationals.
Ms. Wong, on the earlier answer you gave to Justice Gorsuch on the temporary sojourners cases, those were distinct cases, correct, where the parents had come to the U.S. and didn't want to give citizenship to their kids, took them out immediately, correct?
I'm sorry, Justice Sotomayor, I'm not sure which cases you're referring to.
All right, that we can look at.
Okay.
Ms. Wang, would you agree that the citizenship test in the 14th Amendment is the same as the test in the 1866 Civil Rights Act?
So the words are obviously different. What Wong Kim Ark tells us and what the debates tell us is that the framers, it was the same Congress, obviously, framing both. Congress was trying to do the same thing. with both the 1866 Act and with the 14th Amendment. They wanted to capture the common law exceptions and the Indian tribal exception. They started out with the two separate phrases, not subject to any foreign power, plus excluding Indians not taxed. And as Justice Gray described it in his majority opinion in Wong Kim Ark, they decided to switch to the affirmative phrase, subject to the jurisdiction.
Yeah, well, do they mean the same thing? And wouldn't it be very odd if the citizenship test in the 14th Amendment were broader than the citizenship test in the 1866 Civil Rights Act, particularly in the light of the fact that the 1866 Civil Rights Act was reenacted after the adoption of the 14th Amendment and remained in place until 1940.
Sure, the framers were trying to do the same thing with the language in both.
Okay, so then I think we can turn to the language of the 1866 Civil Rights Act because it's more straightforward. You know, subject to the jurisdiction thereof is like the, you know, the puzzle wrapped in an enigma, wrapped in a mystery, but not subject to any foreign power is pretty straightforward. So let me give you these examples. A boy is born here to an Iranian father who has entered the country illegally. That boy is automatically an Iranian national at birth, and he has a duty to provide military service to the Iranian government. Is he not subject to any foreign power?
Not within the meaning of the 1866 Act, Justice Alito. And that's clear from Wong Kim Ark, and it's clear from the debates. What the framers meant by the phrase not subject to any foreign power was referring to the ambassador exception. If it meant what the government contends, basically not a subject of any foreign power, that another country considers you a jus sanguinis citizen, then lawful permanent residents, all foreign nationals.
Well, ordinary public meaning of that would certainly encompass that boy, would it not?
Justice Alito, if you think that
I like that Justice Alito, on some issues, is completely unambiguous in his opinion. Like, you know that he is opposed to birthright citizenship. It's obvious. His questions aren't hiding the ball. It's very much, how do you explain this?
Yeah,
This
not
is
in
a
the
problem.
least, because I mean, he's especially with the question being that he's referring to Iranian. I mean, yeah, you know that he's like, well, don't they have like he's kind of hinting at that whole sleeper cell like thing of is there, you know, sleeper cells in our country and everything. So he knows exactly what he's talking about, and you know, yeah, no, I actually really enjoyed this kind of line of questioning from him because I think he poked a bunch of holes in the argument for the ACLU.
He's well, ever since Scalia left, you know, Alito and Thomas really like stepped up quite a bit. I mean, Alito was he was kind of middle ground, but he ramped it up a bit. Thomas, of course, became vocal when he was not vocal while Scalia was alive.
It's like Scalia left.
When Scalia was peacefully departed, miraculously under a pillow, randomly with no existing health conditions, and his body was taken away and cremated prior to an autopsy happening of a Supreme Court justice who died in his sleep. Like, he definitely wasn't killed by the Obamas. I mean, that didn't happen at all. Or was it the Bidens at that time? I can't remember which. No, that was Obama's still.
Yeah.
the language of the 1866 Act was ambiguous, as Wong Kim Ark says, the shift to the language of the 14th Amendment, which is the operative text, certainly clears up any ambiguity.
What I said about a boy born to an Iranian father is true of children born here to parents who are nationals of other countries. If I'm correct, it's true to a child who's born here to Russian parents. It's true to a child who's born here to Mexican parents. They're automatically citizens or nationals of those countries and have a duty of military service. It sure seems like that makes them subject to a foreign power.
But again, Justice Alito, that would have meant that the children of Irish, Italian, and other immigrants, which Wong Kim Ark refers to and the framers refer to, would not have been citizens either. Because if the only test is whether that US-born child is considered a citizen by another country under their jus sanguinis laws, then no foreign nationals' children would be
Well,
included in
in all of
citizenship.
those cases, the parents.
Where do we get under this jus sanguinis questioning? That wasn't the argument of the Solicitor General. The argument of the Solicitor General is that it's based on domicile.
Right.
And we allowed Italians and Irish to domicile in the United States. Everybody just hated them, but we allowed them to domicile. And even the slaves, the Irish slaves or indentured servants and the Italian ones, they were once freed. They were immediately allowed to domicile in the United States. The states accepted them as legal residents, and like that. This was not a question of whether or not they were.
And if I recall, they were given the option to also go back. Like they could return, or they could become citizens of. They were given the option, and there were a few I think that returned, but vast majority took the domicile of here and became citizens.
Right, as is kind of the expected outcome. Like that would be who the hell would want to go through the process of going back, especially because a lot of these people would have been second and third generation. The difference being that the 14th Amendment was necessary for the Confederate States primarily. The Union States, I mean, I'm not going to say that they were nice to blacks. Just because they were free states does not mean racism didn't exist, and it was very rampant, obviously. But those states didn't have a problem at least accepting a domicile if someone, if a freedman could come into their state and afford to buy land, they were able to establish a domicile. That wasn't the 14th Amendment existed solely because the Confederate States, being brought back into the Union, didn't want to recognize the citizenship of the former slaves who were black. And again, it goes back to exactly what this was for. Yeah, you could say that there were white slaves. That's true that there were white slaves. There were black slave owners, all of that. But the way that they were treated in the states in which they existed, freedmen who were white were allowed instant domicile. It was recognized immediately. Southern states did not want to do it for blacks.
Could be naturalized, and then the children would be derivatively naturalized when the parents were naturalized. Wong Kim Ark, I'm sorry, the red light is on. Wong Kim Ark has a passage explaining how this court should treat dicta. And it quotes something that John Marshall said. It is well, this is quoting from Wong Kim Ark, it is well to bear in mind the oft-quoted words of Chief Justice Marshall, it is a maxim not to be disregarded, that general expressions in every opinion are to be taken in connection with the case in which those expressions are used. If they go beyond the case, they may be respected, but ought not to control the
Trump's addressing the nation in 15 minutes? Someone said?
Yeah, I just sent you a chat on that the chat was asking about that. I guess it's addressing the war in Iran.
Yeah, I mean, I don't mind stepping over to that and seeing what he says. It seems like an important thing to cover, as long as chat's okay. I do want to finish this stream at some point tonight, but we got about just under 30 minutes of this video left. Hopefully Trump's address isn't too long. Maybe it'll be a 15-minute one rather than like a 2-hour one. That'd be nice. Mr. K has become a new member on YouTube. Thank you, Mr. K. Mr. K says, why is the locals chat not on screen, Nick? I don't have a setup to have the locals chat on screen with a guest. I'll have to work on figuring that out. but presently I just don't have a way to do it. Sledge Entertainment says, I forgot Scalia disappeared abruptly for a seat. Yeah, disappeared abruptly. I mean, he died, then his body was disappeared in the most confusing
Well, he was at
arrangement.
some country club too, wasn't he? Like, wasn't he at some?
He was at a
country
hunting
club?
lodge down
That's
in
what it
a
was.
hunting
Yeah.
ranch down in Texas. But okay, here we go.
Judgment in a subsequent suit when the very point is presented for a decision. So does that fall within the, what's good for the goose is good for the gander rule? That's how Wong Kim Ark treats what was said in the slaughterhouse cases. Should we apply that same rule to Wong Kim Ark itself?
Wong Kim Ark tells you what to make of the slaughterhouse dicta. It was dicta. The issue of citizenship was not at play in slaughterhouse. And in contrast, the parts of the holding, the parts of the decision that I alluded to are the controlling rule of decision. Again, we look to the English common law in construing the 14th Amendment.
Thank you, Counsel. Justice Thomas? Anything further, Justice Alito?
Well, just a couple more questions. So if those who framed and adopted the 14th Amendment had wanted to limit the citizenship test to just those specific groups that you concede fall outside the birthright citizenship rule, why didn't they refer specifically to those groups? Why did they adopt a general rule? They could have said all persons born or naturalized in the United States, excluding Indians not taxed, and those ineligible under common law are citizens of the United States and of the state wherein they reside. Or they could have said all persons born or naturalized in the United States, excluding Indians not taxed, and the children of foreign ambassadors or foreign invaders are citizens of the United States and of the state wherein they reside. But they didn't do that. They adopted a general rule. So what's the explanation?
I would say the Wong Kim Ark tells us what the explanation is, that the framers of the 14th Amendment, after overriding President Johnson's veto, wanted to adopt a universal rule with a closed set of exceptions. And they believed that, subject to the jurisdiction of the United States, did that. And that term does describe both the universal general rule and the common law exceptions, with the sole additional American exception for tribal Indians.
Thank you.
Justice Sotomayor?
Ms. Wang, I don't.
That made no sense. Alito's question was very straightforward. Why didn't they just write it without the line subject to the jurisdiction thereof? Why didn't they just write it where, if they're born within the territorial U.S., they get citizenship? Why did they add that? And we know from the Supreme Court's rule that no words can be added or subtracted from the Constitution or its amendments. Every single word must be addressed because every single word was intentional, debated over, and contemplated. So how did she can stand there and just ignore that phrase is beyond me.
And that's the thing. If you think about it, that's why the 21st Amendment was written the way the 21st Amendment was written, because it replaced the 18th Amendment. And they didn't just strike the 18th Amendment from the rules. They just had to put in the 21st Amendment, which then negated the 18th Amendment.
Yep. I hate when
I agree. And I think it's just like looking at the Second Amendment laws, and whenever you get into debates with people over that, the words are there for a reason. And the words that are there, I agree 100%. If they really just wanted to be anybody born in the United States as a United States citizen, they wouldn't put in there the part about being subjected to the jurisdiction.
Right. It's they didn't write extra words in the Constitution. They sat and painstakingly debated those amendments. They were highly contentious because this was Reconstruction. You had roughly half of the. Now they were a little bit quieter because they just had their ass whooped in a war. So they were a little bit brought to heel. You got to step away for a minute.
Yeah, just for a second. I'll be right back.
Yep, no worries. All right, we'll keep going while he's away.
I've not quite understood the Solicitor General's argument.
You've not quite
that
understood anything.
lawful domicile somehow changes the U.S.'s dominion over a person or allegiance. Even in Justice Alito's examples, if your parents are Iranian, if you get lawful permanent residency here, that child still, by their laws, when it leaves the United States, must serve in the Iranian army, correct?
Well, I don't know the answer to that. What I can tell you is that under Wong Kim Ark, the court says, we don't care about problems of dual nationality. We don't look to other countries' laws in construing our 14th Amendment.
Well, it was undisputed there that Wong Kim Ark's parents owed loyalties to China, correct?
Sure, yes.
What I'm saying is, even if you become a permanent resident, you're not a U.S. citizen. So your
Correct.
primary loyalty still remains with your citizenship country, wherever you came from.
That's right, Justice Sotomayor. I take your point now.
You understand what I'm saying? And during temporary, whether it's lawful or unlawful, temporary presence in the United States, you are subject to the U.S. laws, correct?
That's right. The question that the 14th Amendment asks is whether the U.S.-born child is subject to U.S. jurisdiction when they're born.
Meaning, are they within the U.S. territory?
Exactly, other than people covered by that closed set of exceptions.
Okay, thank you.
That's right. In other words, the government's rule, which really is looking at whether someone has a divided allegiance because they're a citizen of another country, would exclude the children of all foreign nationals, and that isn't what they're saying.
Exactly. So the only way that allegiance, lawful or unlawful, has no play in this question.
I would say that the relevance of allegiance is the relevance under the English common law rule that's embodied in the 14th Amendment. All persons born in the territory of the sovereign owe natural allegiance.
Except for the three limited exceptions.
Precisely.
Justice Kagan?
I think I'd like to take you back to the first question that Justice Alito asked General Sauer, and it was this question of what do we do if we think we have a new problem that didn't exist at the time of the 14th Amendment? I don't think, actually, that the U.S. government argues the case this way, but let's put the U.S. government's arguments aside and just ask something like, well, everything that you're saying would suggest an answer to the question of people who, the children of people who are temporarily in the U.S. but here lawfully. Is there any way that there might be a different answer with respect to the children of people who are here unlawfully because of this new problem issue that Justice Alito has raised?
No, there is no difference. And of course, the government's arguments as to people who are unauthorized immigrants in this country all runs through and hinges on their domicile requirement. The first thing I would say in response is that, once again, it's crystal clear from Wong Kim Ark and from the debates that the framers of the 14th Amendment meant to have a universal common law rule of citizenship subject to the closed set of exceptions. And we can't take the current administration's policy considerations into account to try to re-engineer and radically reinterpret the original meaning of the 14th Amendment. The second point I would make is that, in fact, the framers did consider the concept and the actual problems of immigration that were coming up at that time. In addition to this, notable exchange between Senator
doesn't mean that
Senator
they
Cowan
thought
and
about
Senator.
what was going to happen now, 200 and whatever years later.
Yeah, it's the same. The same thing. We all think the same. All the problems are the same. Everything's the same. There was no.
Hannes, where Cowan says, if we have this citizenship clause as part of the Constitution, we are going to encourage these what he called gypsies, Roma, in Pennsylvania, whom he characterized as invaders, trespassers and lawbreakers will encourage them to come into our country because their children will be citizens. He says, Senator Conness, in your state of California, you will be facing a mass flood of Chinese immigration if we adopt the citizenship rule. And Senator Conness himself, an Irish immigrant, says, yes, and I am voting for that because I believe in citizenship by virtue.
That's not what he said. He said, yes, and I believe that I'm voting for that.
Of birth without regard to parentage. And the third point I would make is a historical one, which is that recall that at the time the framers are thinking about birthright citizenship, there just been 15 or 20 years of unprecedented immigration from Ireland. The Know Nothing Party was dominant in the 1850s.
We're about
just
to switch
a
to
decade
Trump.
earlier. And they were vehemently opposed to Irish immigration. They believed Irish Catholic immigrants were unassimilable and could never become Americans. But even the Know Nothing Party members of Congress believed that the children born in the United States to those Irish immigrants were citizens like anyone else. That's the intuition that the framers of the 14th Amendment had. Contrary to the government's arguments now, they wanted to grow this country. They wanted to make sure we had a citizenry to populate the military, to settle the country. And they also had an intuition that was consistent with the founding aversion to inherited rights and disabilities.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
On Lynch v. Clark, which you cite several times in the briefing today, which I appreciate, the government's response is that that decision was questioned at the time and went unmentioned in congressional debates about the 14th Amendment. I just want to get your response to that point on Lynch.
Sure, not true, though the Lynch was not specifically mentioned by name in the 14th Amendment debates. It was a couple months earlier in the debates on the 1866 Act, where Senator Trumbull, Senator Lawrence.
Don't tell a judge he's wrong, ever.
Yeah.
Ever.
Lawrence talks about the great case of Lynch versus Clark.
Just a second. My computer's having an autism issue. it's just deciding to go have a memory leak. I think we may be. Let's see. I'm checking this Trump stream. It's supposed to be starting now. Here it is. Let me switch over. Why are you going so slow?
Thank you very much. My fellow Americans, good evening. Let me begin by congratulating the team at NASA and our brave astronauts on the successful launch of Artemis 2. It was quite something. It will be traveling further than any manned rocket has ever flown and will very substantially pass the moon, go around it, and come back home from a distance that has never been done before. It's amazing. They are on the way, and God bless them. These are brave people. We want to God bless those 4 unbelievable astronauts. As we speak this evening, it's been just 1 month since the United States military began Operation Epic Fury, targeting the world's #1 state sponsor of terror, Iran. In these past 4 weeks, our armed forces have delivered swift, decisive, overwhelming victories on the battlefield. Victories like few people have ever seen before. Tonight,
Nobody's seen
Iran's
victories
Navy is
like
gone.
these.
Their Air Force is in ruins. Their
They were
leaders,
huge.
most of
Huge
them
victories.
terrorist regime they led, are now dead. Their command and control of the Islamic Revolutionary Guard Corps is being decimated as we speak. Their ability to launch missiles and drones is dramatically curtailed, and their weapons factories and rocket launchers are being blown to pieces. Very few of them left. Never in the history of warfare has an enemy suffered such clear and devastating large-scale losses in a matter of weeks.
Just tell the
Our
Ayatollah
enemies
you're
are
fired.
losing in America, as it has been for 5 years under my presidency, is winning, and now winning bigger than ever before. Before discussing this current situation, I also want to thank our troops for the masterful job they did in taking the country of Venezuela in a matter of minutes.
That was
quick,
amazing.
lethal, violent, and respected by everyone all over the world. After rebuilding our military during my first term, we have by far the strongest military anywhere in the world. And now we're working along with Venezuela and are, in a true sense, joint venture partners. We're getting along incredibly well in the production and sale of massive amounts of oil and gas, the second largest reserves on Earth after the United States of America. We're now totally independent of the Middle East, and yet we are there to help. We don't have to be there. We don't need their oil. We don't need anything they have, but we're there to help our allies. Tonight, I want to provide an update on the tremendous progress our warriors have made in Iran and discuss why Operation Epic Fury is necessary for the safety of America and the security of the free world. From the very first day I announced my campaign for president in 2015, I have vowed that I would never allow Iran to have a nuclear weapon. This fanatical regime has been chanting death to America, death to Israel for 47 years. Their proxies were behind the murder of 241 Americans in the Marine barracks bombing in Beirut, the slaughter of hundreds of our service members with roadside bombs. They were involved in the attack on the USS Cole, and they carried out the countless other heinous acts, including the just horrible, bloody atrocities of October 7th in Israel, something that most people have never seen anything like it. This murderous regime also recently killed 45,000 of their own people who were protesting in Iran. 45,000 dead. For these terrorists to have nuclear weapons would be an intolerable threat. The most violent and thuggish regime on earth would be free to carry out their campaigns of terror, coercion, conquest, and mass murder from behind a nuclear shield. I will never let that happen, and neither should any of our past presidents.
Wait,
This situation has been
past
going on
presidents?
for 47 years and should have been handled long before I arrived in office. I did many things during my 2 terms in office to stop the quest for nuclear weapons by Iran first, and perhaps most importantly, I killed General Qasem Soleimani in my first term. He was an evil genius, brilliant person, a horrible human being, however, the father of the roadside bomb, and he lived just horrible what he did. Iran would have been perhaps in far better, stronger position. Had he lived, we would have had probably a different conversation tonight. But you know what? We'd still be winning and winning big. And then, very importantly, I terminated Barack Hussein Obama's Iran nuclear deal, a disaster. Obama gave them $1.7 billion in cash, green cash. Took it out of banks from Virginia, D.C., and Maryland, all the cash they had.
That's where all our
Flew it
pennies
by
went.
airplanes in an attempt to buy their respect and loyalty, but it didn't work. They laughed at our president and went on with their mission to have a nuclear bomb. His Iran deal would have led to a colossal arsenal of massive nuclear weapons for Iran, and they would have had them years ago, and they would have used them. It would have been a different world. There would have been no Middle East and no Israel right now, in my opinion, the opinion of a lot of great experts, had I not terminated that terrible deal. And I was so honored to do it. I was so proud to do it. It was so bad right from the beginning. Essentially, I did what no other president was willing to do. They made mistakes, and I am correcting them. My first preference was always the path of diplomacy, yet the regime continued their relentless quest for nuclear weapons and rejected every attempt at an agreement. For this reason, in June, I ordered a strike on Iran's key nuclear facilities, an Operation Midnight Hammer. Nobody's ever seen anything like it. Those beautiful B-2 bombers performed magnificently. We totally obliterated those nuclear sites. The regime then sought to rebuild their nuclear program at a totally different location, making clear they had no intention of abandoning their pursuit of nuclear weapons. They were also rapidly building a vast stockpile of conventional ballistic missiles and would soon have had missiles that could reach the American homeland, Europe, and virtually any other place on Earth. Iran's strategy was so obvious. They wanted to produce as many missiles as possible, and they did, with the longest range possible, and they had some weapons that nobody believed they had. We just learned that out. We took them out. We took them all out so that no one would really dare stop them. And their race for a nuclear bomb, a nuclear weapon like nobody's ever seen before. They were right at the doorstep. For years, everyone has said that Iran cannot have nuclear weapons, but in the end, those are just words if you're not willing to take action when the time comes. As I stated in my announcement of Operation Epic Fury, our objectives are very simple and clear. We are systematically dismantling the regime's ability to threaten America or project power outside of their borders. That means eliminating Iran's Navy, which is now absolutely destroyed, hurting their Air Force and their missile program at levels never seen before, and annihilating their defense industrial base. We've done all of it. Their Navy is gone, their Air Force is gone, their missiles are just about used up or beaten. Taken together, these actions will cripple Iran military, crush their ability to support terrorist proxies, and deny them the ability to build a nuclear bomb. Our armed forces have been extraordinary. There's never been anything like it militarily. Everyone is talking about it, and tonight I'm pleased to say that these core strategic objectives are nearing completion. As we celebrate this progress, we think especially of the 13 American warriors who have laid down their lives in this fight to prevent our children from ever having to face a nuclear Iran. Twice this past month, I have traveled to Dover Air Force Base, and it's been something. I wanted to be with those heroes as they return to American soil, and I was with them and their families, their parents, their wives, their husbands. We salute them, and now we must honor them by completing the mission for which they gave their lives. And every single one of the people, their loved ones said, please, sir, please finish the job, every one of them. And we are going to finish the job, and we're going to finish it very fast. We're getting very close. I want to thank our allies in the Middle East, Israel, Saudi Arabia, Qatar, the UAE, Kuwait, and Bahrain. They've been great, and we will not let them get hurt or fail in any way, shape, or form. Many Americans have been concerned to see the recent rise in gasoline prices here at home. This short-term increase has been entirely the result of the Iranian regime launching deranged terror attacks against commercial oil tankers in neighboring countries that have nothing to do with the conflict. This is yet more proof that Iran can never be trusted with nuclear weapons. They will use them, and they will use them quickly. It would lead to decades of extortion, economic pain, and instability worse than we can ever imagine. The United States has never been better prepared economically to confront this threat. You all know that. We built the strongest economy in history. We're going through it right now, the strongest in history. In 1 year, we've taken a dead and crippled country. I hate to say that, but we were a dead and crippled country after the last administration and made it the hottest country anywhere in the world by
Very
far with no
warm.
inflation. Record-setting investments coming into the United States, over $18 trillion, and the highest stock market ever, with 53 all-time record highs in just 1 year. It all positioned us to get rid of a cancer that has long simmered. It's known as the nuclear Iran, and they didn't know what was coming. They've never imagined it. Remember, because of our drill baby drill program, America has plenty of gas. We have so much gas. Under my leadership, we are #1 producer of oil and gas on the planet, without even discussing the millions of barrels that we're getting from Venezuela. Because of the Trump administration's policies, we produce more oil and gas than Saudi Arabia and Russia combined. Think of that, Saudi Arabia and Russia combined. And that number will soon be substantially higher than that. There's no country like us
Drill, baby,
anywhere in the
drill.
world, and we're in great shape for the future. The United States imports almost no oil through the Hormuz Strait and won't be taking any in the future. We don't need it. We haven't needed it, and we don't need it. We've beaten and completely decimated Iran. They are decimated, both militarily and economically and in every other way. And the countries of the world that do receive oil through the Hormuz Strait must take care of that passage. They must cherish it. They must grab it and cherish it. They can do it easily. We will be helpful, but they should take the lead in protecting the oil that they so desperately depend on. So to those countries that can't get fuel, many of which refuse to get involved in the decapitation of Iran, we had to do it ourselves. I have a suggestion. #1, buy oil from the United States of America. We have plenty. We have so much. And #2, build up some delayed courage. Should have done it before. Should have done it with us, as we asked. Go to the Strait and just take it. Protect it. Use it for yourselves. Iran has been essentially decimated. The hard part is done, so it should be easy. And in any event, when this conflict is over, the Strait will open up naturally. It'll just open up naturally. They're going to want to be able to sell oil because that's all they have to try and rebuild. It will resume the flowing, and the gas prices will rapidly come back down. Stock prices will rapidly go back up. They haven't come down very much, frankly. They came down a little bit, but they've had some very good days over the last couple of days. We've done actually much better than I thought, but we had to take that little journey to Iran to get rid of this horrible threat. With our historic tax cuts, where
Over a
people
couple
are
of days,
just
they've done
now
very good
talking
days.
about receiving larger refunds than they ever thought possible. They are getting so much more money than they thought. That's from the great, big, beautiful bill. Our economy is strong and improving by the day, and it will soon be roaring back like never before. It will top the levels that it was a month ago. I've made clear from the beginning of Operation Epic Fury that we will continue until our objectives are fully achieved. Thanks to the progress we've made, I can say tonight that we are on track to complete all of America's military objectives shortly, very shortly. We're going to hit them extremely hard over the next 2 to 3 weeks. We're going to bring them back to the Stone Ages where they belong. In the meantime, discussions are ongoing. Regime change was not our goal. We never said regime change, but regime change has occurred because of all of their original leaders' death. They're all dead. The new group is less radical and much more reasonable. Yet if during this period of time no deal is made, we have our eyes on key targets. If there is no deal, we are going to hit each and every one of their electric generating plants very hard and probably simultaneously. We have not hit their oil, even though that's the easiest target of all, because it would not give them even a small chance of survival or rebuilding. But we could hit it, and it would be gone, and there's not a thing they could do about it. They have no anti-aircraft equipment. Their radar is 100% annihilated. We are unstoppable as a military force. The nuclear sites that we obliterated with the B-2 bombers have been hit so hard that it would take months to get near the nuclear dust. and we have it under intense satellite
He said a
surveillance and
nuclear
control.
dust.
If we see them make a move, even a move,
Very dusty
forward,
and
we'll
irradiated.
hit them with missiles very hard again. We have all the cards, they have none. It's very important that we keep this conflict in perspective.
Depending on which news channels you
American
listen to,
involvement
they
in
say that
World
it would
War
still
I
be nuclear no
lasted
matter
1
what
year,
out there. So
7 months and 5 days. World War II lasted for 3 years, 8 months, and 25 days. The Korean War lasted for 3 years, 1 month, and 2 days. The Vietnam War lasted for 19 years, 5 months, and 29 days.
The
Iraq
Venezuelan war
went
was
on for
38
8 years,
seconds.
8 months, and 28 days. We are in this military operation so powerful, so brilliant against one of the most powerful countries for,
it was over before
32
Maduro
days.
even knew what happened.
And the country has been eviscerated and essentially is really no longer a threat. They were the bully of the Middle East, but they're the bully no longer. This is a true investment in your children and your grandchildren's future. The whole world is watching, and they can't leave the power, strength, and brilliance. They just can't believe what they're seeing. They leave it to your imagination, but they can't believe what they're seeing. The brilliance of the United States military. Tonight, every American can look forward to a day when we are finally free from the wickedness of Iranian aggression and the specter of nuclear blackmail. Because of the actions we have taken, we are on the cusp of ending Iran's sinister threat to America and the world. And I'll tell you, the world is watching. And when we do, when it's all over, the United States will be safer, stronger, more prosperous, and greater than it has ever been before. May God bless the men and women of the United States Armed Forces, and may God bless the United States of America. Thank you very much, and good night.
There we go. Short and sweet, really.
I figured it'd be short. He was standing.
Sorry, everyone. I didn't mean for that to happen. Didn't mean to take you off guard like that.
Keeping track of your competition or what?
It auto played Kurt. I don't know. I think it knows that it's my favorite YouTube channel. Harvey Production says, can you talk about the Dems drinking hot diarrhea? No, I don't know anything about that. That sounds disgusting and horrible. The Rick Nikita says, we keep winning the war. I mean, I think we are winning the war, I guess. And he also says, this speech might make me start drinking again. I mean, it wasn't that. I thought it was fine. It was a status update. It was really a terrific status update. Really, I've never seen anything quite as good. A lot of people are telling me.
So Nick, somebody said in the chat, like, oh, it's a war crime. What are your thoughts on whether or not him bombing their infrastructure and everything is a war crime? Is that part of the reason why he wants to get out of NATO?
How would that be a war crime?
Well, according to, and again, it just depends on what sources you're looking at or anything like that. They say that the bombing of civilians is considered a war crime. Now, granted, he's not talking about bombing civilians. He's just talking about blowing up their infrastructure and sending them back to the Stone Age. I don't think it's a war crime to blow up their, to blow up their electrical plants and things like that.
Not at all.
But yeah, I mean, again, I think that was one of the things that I thought was so funny. It's like, if it was really a war crime, somebody would have shut his ass down on that already and been like, sir, you can't say that. Sir, if you're asking to be impeached again, sir.
Just because infrastructure of a nation is civilian facing primarily does not mean that infrastructure is an invalid military target, because the civilian infrastructure necessarily supports the military when necessary. The military utilizes the electrical grid. They don't have their own separate grid. You can't say that the electrical grid is not a valid military target because their military relies on the electrical grid. just because the civilians also do doesn't mean that you're attacking civilians. It may be a civilian target in the sense that it benefits the civilians of the nation, but that doesn't mean it's civilians. What they're talking about as a war crime would be the intentional targeting of civilians, the people, not the civilian infrastructure or civilian buildings. If those buildings have been co-opted into the use of the foreign, of the military.
So you're meaning, like those cluster bombs that Iran is letting off over Tel Aviv that are, intentionally destroying people's houses and stuff. Oh, you mean that kind of war crime? Because I'm pretty sure what our president is doing is trying to eliminate that.
Yeah, and I mean, again, this is one of those things where Geneva is a weird thing, because Geneva changed all of human history and the way we approach war and the way we deal with international conflicts or international disagreements that become conflicts. You used to have a war. If you wanted more land, you had a war. You declared it and you went and took stuff over. Geneva says we can't do that anymore, and the map is static. The map has changed a little bit since then, but not as much as it used to. This idea that that there are rules around attacking something that civilians use is wild. Like that's crazy. How could you have a war where you can't attack infrastructure? They don't want us bombing schools and hospitals. Those things, are off limits targets, and the intentional targeting of them is a war crime under Geneva. But that's the only reason that it is because World War II was so horrific with the civilian bombing in the UK and in Germany. The idea was that they could punish either side's civilian population so much that there would be a general fatigue of the war and they would back out. That didn't work. It actually fortified the resolve on both sides, and it just caused a lot of civilian deaths. And that's, they didn't want that anymore. But that's different in all of human history too. Geneva changed everything about how we do war, and war kind of doesn't make sense under the Geneva Convention anyway anymore. Like it's like, what is the purpose of this? So, but the entire idea of taking out the infrastructure is to take out the ability to conduct war itself, and that wouldn't be a war crime under any definition that I've seen.
And that's how the North won the Civil Wars. They took out the supply lines and they took out the infrastructure and everything that the South was going to be able to get to. So, yeah, I mean, again, you take it out. The whole point is not making peace through, like, war is war. As a vet, I'm going to say it, as a vet of, of Operation Enduring Freedom, you do what you have to do to win the war.
Yeah. And what people don't understand is that this method of war is what we've been asking for decades. That was the problem with Operation Enduring Freedom. The enduring part is like, we don't want this to go on. We don't want to occupy a nation for 10 years. If we obliterate Iran's ability to produce, nuclear weapons with whatever nuclear technology they're doing and their refining process. I talked about this before, but heavy water refineries are one way to produce nuclear fuel, and that you don't need to, though. We have light water reactors now. Light water reactors are a newer technology than heavy water, but the heavy water reactors produce the materials that are also used in weapons. Light water doesn't. And so if we take away their ability to produce or to utilize their heavy water reactors, if we destroy that facility, then it takes them a very long time to get back to where they were. And it's a much more sensible option for them to adopt what we've been asking for decades now, which is just the entire world will help Iran with a light water nuclear program. They're all ready to do that. And they have been. That's always been on the table.
And Marco Rubio, and all of our people have offered. I mean, part of the the negotiations where we would provide them for free, non-nuclear grade uranium so they could have nuclear power in their country, and they rejected it. So
yeah,
it's on you.
Yep. And so this is the way it should be done. I think Iran, it might be going a little longer than Trump planned, but on the scale of things, we're still at barely a blip on the time on a war timeline that we become accustomed to. And this is what we want. We want the U.S. military, which is, as he said, it's very powerful. I've heard from a lot of people. They said this is a powerful military. I looked at it. It really quite was powerful. But we want them to go in, obliterate the target, and go home. And we don't want our troops sitting over there as targets under shitty rules of engagement, where they have to get killed in droves before we can even respond. Where we're out patrolling and having IEDs blowing up our troops in our cars. Like we don't want to do that. We want to go in there. And what Trump has done is effectively use the Navy and the Air Force without deploying ground troops to just annihilate, Iran's capacity first to conduct war, and soon it'll be Iran's capacity to have a functional government. Being bombed back to Somalia is really on the table. And if you think about what happens to a nation and its ability to just conduct itself, if you eliminate the electricity from it, just take it out, eliminate electricity, blow up some bridges, and suddenly every major city becomes a risky proposition to remain in, and the populace becomes unrestful very quick, and they will change their government, like they'll have to. But that's on the table. It's entirely in Iran's hands to avoid that, and we can do it with pretty minimal casualties on their side. We have the ability to conduct war this way, but we have crippled ourselves in doing that in the past. In my entire lifetime, we've crippled ourselves with rules of engagement that make no sense, that we hamstring ourselves, and we don't need to do that anymore. And Trump came in and did war the way we all said. We wish this was how war was being conducted in Iraq and Afghanistan. And now we're doing it, and we saw how it worked in Venezuela. And I think, assuming he keeps up with it in Iran and doesn't back off, we should have exactly what he said. It's not going to be long, and we'll be done. And as long as he holds to that, I think the unpopularity of this conflict will fade away really quickly if he actually accomplishes the goals in a quick time. But we'll see.
And our gas prices go back down.
Right.
Then the popularity will definitely.
So my car, my Mustang, runs on premium, and it's like it's been stored all winter. Premium was like $2.30 all winter, and then I finally get to take it out, and it's like $4.50 a gallon now. Damn it! Come on, Trump.
It's $5 here in Arizona. Like I think it's dropped down a little bit, but I mean, I work from my house, so I don't have to go very far for driving a lot, so it's nice. But yeah, no, I'm not moving my car unless I absolutely have to. I have a big I got a big old Toyota truck. It drinks some gas.
Yeah, I bet it does. Yeah, Looper says this is completely different. This is that was regime change. Well, I mean, this is too. Make no mistake. He went after Soleimani, and now he killed Khamenei or whatever. And then I think they may have killed the next appointed guy. It's kind of hard to say if we got him or not. But they're interested in regime change in Iran. But they're giving the regime an option to stay, basically. Like you can be self-governing and you can stay in control of your nation, but you have to come to the terms that the rest of the world does not want you to have nukes, and you're not going to. And as long as we're not pussies, we'll accomplish that. Otherwise, their country will be suffering for a while. Okay, let's finish up this thing. There's about just under 20 minutes left, and then we can wrap up at that point.
where it was conclusively shown that all children born here are citizens without any regard to the political condition or allegiance of their parents. And then, of course, they discuss the children of temporary sojourners elsewhere without mentioning Lynch.
Just want to isolate a point that you've mentioned, which is if the 14th Amendment used the phrase not subject to any foreign power, to give a much tougher argument. And then earlier, I think you indicated that that's what they meant, even though they didn't say it. I just want to give you a chance to unpack that, because I think that's if it said that, I think our history would be a little different. And I think the text, even put aside the history, because that's speculation, the text would be quite a bit different.
Sure. So let me answer in 3 parts. The first is that Wong Kim Ark tells us that the court already dealt with this and said, look, the framers were trying to do the same thing with the language of the 1866 Act. To the extent you think that the language is ambiguous or not as good, let's look at the operative text subject to the jurisdiction thereof. The second point I would make is that it's clear from the debates that the framers, in using the phrase not subject to any foreign power, were thinking about ambassadors. And I believe that Senator Wade at one point says, well, I wanted to start with the phrase, all persons born in the United States are US citizens. But then I thought, oh wait, we have these temporary visitors. In fact, the government points to this quote. He says, so there are these temporary visitors we can't make and we can't make their children citizens. That's ambassadors, and that's very clear from that.
So if that had been the text, your argument would be that was understood to be narrower than its text would read.
Yes.
But that's not the text, so I guess we don't need to deal with that.
Sure, and that brings me to my third point, which is you can't read not subject to any foreign power the way the government urges you to without making the children of all foreign nationals non-citizens, and that's clearly not what the framers were doing.
Justice Alito and Justice Kagan raised an interpretive question that I think is important, which is, are the exceptions, you've used the word closed many times, frozen, or do we reason by analogy to the exceptions that existed based on things that were unforeseen at the time? This comes up in the Second Amendment now, comes up in free speech law. And how do we think about whether it's possible that there could be an additional exception based on modern circumstances, reasoning by analogy to the exceptions that exist? I'm thinking in particular about the non-citizens unlawfully in the country, not the temporary part, but the non-citizens unlawfully in the country.
Sure.
Could you reason by analogy? You've used the phrase, several times, I think, the fiction of extraterritoriality, and could that apply, and if not, why not?
Sure. So here, I agree with Professor Whittington, who says that the government's position here is not positing a new application of the rule, but a challenge to the rule itself. And I think that's right. We know that the 14th Amendment's rule does provide for a universal rule with a set of closed exceptions. Wong Kim Ark says so at least twice. It says in an earlier passage that the framers were not trying to introduce any new exceptions. To the contrary, they were trying to foreclose any caste-creating exceptions like the court had created in Dred Scott. The second reason we know this is that the debates themselves had the framers saying, number one, we are declaring what is already the law in this country, at least for white Americans, and we are putting any further exceptions to birthright citizenship outside the reach of any future Congress. They were very concerned about that. That's the whole impetus for the Citizenship Clause. And the third thing I would say is that that it would be contrary to the central purpose of the 14th Amendment Citizenship Clause to admit new exceptions. For all those reasons, the entire history of the Citizenship Clause is driven by the notion that we don't want to have any other exceptions.
And then relatedly, just a separation of powers point, but get your answer. I understand your point about the executive order, but Congress's authority under Section 5 of the 14th Amendment, I guess the answer you just gave means they don't have any authority to look at this, even if they passed it 435 to 0 in the House and 100 to 0 in the Senate and said, we're carving out a new, by analogy to the existing categories, a new exception, your point is, no, they're closed, they're frozen forever.
Correct. And the way I would put it is that the citizenship clause of the 14th Amendment, again, has a universal rule with a closed set of exceptions. It sets a floor. So the Congress has, under the naturalization clause, the power to expand citizenship to other people not covered by the 14th Amendment, and obviously they have in many ways, but they can't go below that floor that the Constitution sets.
I think Mr. Sauer acknowledged that, and you mentioned this in your opening, that if we agree with you on how to read Wong Kim Ark, then you win. So that could be if we did agree with you on Wong Kim Ark, that could be just a short opinion, right? That says the better reading is respondents' reading. Government doesn't ask us to overrule, affirmed.
Yes.
That's that. Then last question, though, why would we address the constitutional issue? This is the last one. Why would we address the constitutional issue, given your argument on the statutory? Our usual practice, as you're well aware, of course, is to resolve things on statutory grounds and not to do a constitutional ground.
Sure. You know, I think we obviously have these two paths to a win here. We're happy to win on either or both of them. I do think it would be prudent for the court to reaffirm its decision in Wong Kim Ark, where it's a landmark decision about the definition of national citizenship in this country. I just think it would be prudent for the court to go ahead and reaffirm that, but of course we're happy to take a win on any ground.
Thank you.
Thank you.
Wow.
Justice Jackson? I'm
Right?
sorry.
Right?
Jackson.
So I have a question about the exceptions again. So in your interchange with Justice Kavanaugh just now, you were talking about it as a closed set of exceptions. And said that way, it sounds like exceptions that people had in mind at the time of the ratification, but that were not explicit in the amendment. But I took your brief to be arguing that subject to the jurisdiction thereof is the language in the 14th Amendment that refers to those exceptions. Am I right?
That's right.
Okay.
It describes them.
It describes them. And would you say, this goes back to a question that Justice Gorsuch asked General Sauer, our relationship to the Indian tribes is different today than it was at the time that the 14th Amendment was ratified. Let's put aside Section 1401. Is a tribal Indian born on a reservation today on tribal land a natural-born citizen under the 14th Amendment?
Under the 14th Amendment, no. Of course, Congress has provided for citizenship for all tribal members in the
By
1924 Act.
by statute. And so is that because what's subject to the jurisdiction of meant when you say closed set of exceptions, it means that the jurisdiction as it existed at the time of the 14th Amendment is still the jurisdiction today? So let me just be a little bit clear. You know, Justice Kavanaugh asked you if we could create new categories by analogy. So there may be other sorts of people who were present here to whom this subject to the jurisdiction in the same way that we were talking about, you know, the bubbles around ambassadors or the soil of occupied territory or the soil of tribal land. Perhaps those new carve-outs could exist by analogy today, like if the United States carved out some portion of some state and suspended it from its jurisdiction. Wouldn't the principle still apply?
No, Justice Barrett, for two reasons. The first is, again, that there is a closed set.
But why is it closed? The language doesn't say it's closed.
Sure. We know it's closed because Congress's, the very purpose of the Citizenship Clause was to foreclose new exceptions. That's clear from the debates. And I would say that the language describes a closed set as well, because you can't imagine another situation. The government's trying to make us imagine another situation, right? They say, look, what if Congress, in order to do an end run, in order to change the meaning of the 14th Amendment as to unauthorized immigrants' children, Congress can say, we are not going to exercise jurisdiction.
Well, not quite, because it's redefining jurisdiction. It's not quite analogous, right? Because the government's domicile theory is a little bit different than the jus soli theory, right?
Sure, that's right. I'm just saying that in the second step of their argument as to undocumented immigrants, where they have to get around the fact that undocumented immigrants, by and large, are domiciled in the United States. They're trying to say, look, we're gonna manipulate the law either to define domicile or to.
Nope. Undocumented immigrants cannot be domiciled in the United States. The fact that they acquire and obtain access to property does not mean that they can be domiciled. Because they cannot intend to stay indefinitely, they're subject to removal.
Because they're breaking the law.
Right.
Yeah, exactly. You're breaking the law, so you cannot have the intent to stay here. I mean, you can have the intent to stay here all you want, but it doesn't mean you're going to be able to. So, yeah, you come across the border and you're like, oh, I have the intent. No, you don't, because if you get found, you're going back.
Many undocumented people are domiciled. Tell that to ICE. when they warrantless walk in your door, arrest you, and you complain, and the judge says, you can complain all day, but you don't have a right to be not arrested awaiting departure. You're gone. Bye.
And that was one of the cases the Supreme Court even took up and said that, like Trump's deportation to the Venezuelan prison was not unconstitutional because they didn't have the right to be here. So Supreme Court's already ruled on that. You don't, an illegal person or an illegal alien does not have the right to be here, which means they are not subjected to the jurisdiction, which means this entire argument that ACLU is making is flawed.
Yeah. I mean, and to analogize it for people, if someone breaks into your house and you have house rules about like taking off your shoes and washing your own dishes. If someone breaks into your house, goes into their, into your fridge and makes a sandwich, you just throw them out of your house. You don't make them take their shoes off. You don't make them follow the house rules. That's ridiculous. You just get them out because they don't have a right to be there. And it's the same with our country. You can't just walk across the border and being like, ha, you're stuck with me now. That's not how it works. That can't be. It's completely irrational to think that that would be an effective way to run the country. And it's so wild that people think that no, this is what we should do. Why would that be the case ever? All right, here we go.
Carve out to say, just wave a magic wand and say these babies are not subject to the jurisdiction of the United States. There's still a missing factor under that original meaning of the 14th Amendment, and that's that there is another sovereign who can exercise jurisdiction over this person, even though they're in the United States. And this gets me back to a question you asked Justice Alito. The difference between an ordinary non-ambassador foreign national and everyone who's subject to one of those jurisdictions is that even if you take the government's argument and say a foreign national is subject to their country of nationality's jurisdiction in the United States, is actually not true. If I'm a French national in the United States, France cannot come into the United States, arrest me, and try me for a crime under French law.
Wait, yes, they can. If you're a French citizen in the United States, especially illegally, if you're illegally present, do you think that the French government can't come in and extradite you? I mean, they'd ask for cooperation with the United States, but they can absolutely come in and make an arrest and extradite you out. Here's the question. If the French government comes in and arrests you and takes you back to the French embassy for removal back to France, and what are you going to complain to the U.S. that you should be allowed to stay? What the hell sort of idea is that? She's ignoring the fact that temporarily present people are subject to the United States because we have either a treaty with the country that doesn't require a visa, like Canada, for example, or we have a visa in which permission is given to be here. You have permission through the visa program to be here, and you're now subject to our jurisdiction. We're borrowing the authority of your parent country for a limited amount of time. That's That's how the visa process works. So you are subject to jurisdiction if you're temporarily here with permission. But if you're here without permission, if you think a foreign government arrests you and to take you back home because you're unlawfully present here, that you can appeal to the United States to stay. I mean, you can appeal, but that's a discretionary decision based on, rules of asylum status.
Well, and they're going to reach out to us to ask for extradition anyway. So they're like, you're going to be extradited by the U.S. government no matter what. So, then that's the thing. But I want to go back to your comment about somebody breaking into your house and, you're going to report them out. Not in Arizona. In Arizona, you walk into my house, I'm calling 811 and I'm not calling 911.
Yes, exactly.
Because it's a constitutional carry state here. So that's why we don't have as many break-ins in Arizona as other states.
It's amazing how that helps really quickly. Like in Polk County, Florida. It's like, if someone breaks in your house, just kill him. The sheriff just kill him.
You cross that threshold, it's fair game.
Yeah. Not here in Minnesota, though. We have castle doctrine where we don't have a duty to retreat, but you can't just obliterate someone. You still, even though we have castle doctrine and you have the ability to defend yourself, you have a high bar for justifying that force under the law. You just don't have a duty to retreat. But I think
Minnesota's it's definitely blue now. So I mean that makes a lot of sense.
You
got Tampon Tim as your governor. So
that video, the guy who he went to one of the protests and someone was blasting an air horn in his ear and he just knocks him out and then KOs like 4 other people who are chasing him.
Yeah.
That guy got assault charges. And the theory is that he had a duty to retreat. And so even though he's literally being assaulted by the air horn, he was supposed to leave the premises rather than defend himself. And so he's charged right now. And he's going to have to, it'll be questionable whether or not he goes to prison jail, because it'd be misdemeanor assault probably. But yeah, he's expected to retreat from the assault he was enduring because he's in a public space. It's crazy. Our laws are insane. Oh, and your front lawn is considered a public space. So we have castle doctrine within the home, but if you're out on the front lawn or the curtilage, you have a duty to retreat, which is, again, even if deadly force is brought in, you have a duty to retreat into your home. It's crazy.
Yeah. F that noise.
And that's what sets ordinary foreign nationals apart from ambassadors.
Well, no, I understand. That wasn't quite the hypothetical. I understand that. Let me just ask you. No, that's okay. Let me just ask you one last question about Indians. So I gather what you're saying is that Congress cannot expand the set of.
Why does the Supreme Court get away with saying Indians? Everybody else would be flayed for saying Indians so callously.
Well, the ACLU, their director or whatever has been saying it too, and I think that I even think the general was saying it earlier as well. I was like, wait, did we jump timelines again and make it where that was okay to say it again? But
I think it's because the language of the 14th Amendment says Indians not taxed. So that justifies the use of the term Indians because they're referring to the constitutional language. But it is kind of funny because in every other context, so callously saying Indian, which you don't like using it. It doesn't bother me at all, but I don't mean it disrespectfully. But I do try to say native, but sometimes I say Indian.
And that's just again because I live here and there's several different tribes, and I just try and avoid. Of course, I don't want to offend anybody in that aspect because I have a lot of friends that are Native American. But at the same time, I just there's certain words that right,
and like I said, I don't really care,
and it doesn't offend me if somebody else says it. I don't care if they say it.
Right.
It's my personal choice.
I try to say native when I'm thinking about it. It's just sometimes I just go back because I grew up in Texas in the 80s, Cowboys and Indians. was just the thing. You know, but I still try to say it. But I just find it interesting that the Supreme Court is just so, you know, they're just using Indian like it doesn't matter, which I don't know if that's alarming or refreshing or what.
Somebody on Rumble said census and OMB uses American Indian, Native American is no longer used. So maybe they've changed the verbiage that they use.
Yeah, who knows? I can never keep track. It's too fucking complicated. It's like I do try and be respectful of whatever, but ever since the fucking weirdos took over on the gender issue and like added cisgender and all this extra terminology and created a whole new lexicon for us, and it's like I'm like, you know, I tried, but now I don't care. Now you guys piss me off because like I was trying hard, and then you added an entire vernacular for me that I now have to learn or else I'm invalidated. No, fuck you. I'm just going to say whatever I want now.
With that said, we need to go back to the Washington Redskins and the Cleveland Indians. That's
yeah. Yeah. And the funny thing is the tribes,
the
local tribes in those areas want to go back. They're like, no, why'd you take that away? They weren't offended.
Definitely. Yeah. The Redskins definitely were like, no, we want it back. And I think that's one of the things Trump's actually trying to do is he's trying to get it to go back. It won't ever happen, but you know,
we need to claw back every inch of free speech and move away from every shackle at any possibility. Like,
and that's why Atlanta said they'll never change their name from the Braves. They're always going to be the Braves just because it's their heritage. So,
yeah,
we'll call them exceptions, right? But you're saying it can't contract them either, and that was the Indian example. So what if, again, putting aside Section 1401, what if our relationship with tribal Indians has changed so much that we would say, no, Indians really are fully subject to the jurisdiction of the United States in the way any other, natural-born citizen is? You're saying that that doesn't change the constitutional status of Indian citizenship?
Let me be clear. What I'm saying is that the meaning of the 14th Amendment is we have to go with the original public meaning. And obviously at the very time that the framers were, thinking about the 14th Amendment, at the time of ratification, that relationship between the United States and tribal nations was in flux, right? The government has made various arguments about Congress's authority, but the way the framers thought about it and the way that Wong Kim Ark describes it is that there was a unique constitutional status, unlike any other relationship between sovereigns in all the world, between the United States and the Indian tribes. And that is what gave rise to the pre-existing exclusion of Indian tribal members from U.S. citizenship, and that's what the 14th Amendment captures.
Justice Jackson?
This is a red herring argument because Indians not taxed is clearly stated within the 14th Amendment's language. There's no reason to ponder or contemplate what they meant, excluding Indians not taxed. If you're an Indian not taxed, boom, we don't need to worry about it. There's no ambiguity there at all. And so this is a weird avenue for them to go down because the Indians not taxed is not a useful reference point for what the 14th Amendment was otherwise saying. It's its own distinct category. There's no overlap. There's no spilling. No one has any question what they mean. If you're a native who's assimilating at the time, who's assimilating into statehood, and you're domiciled in a state rather than on tribal land, you are a native who's taxed at that point. And you see, you're outside of the statute. You don't need, or outside of the amendment. We don't even need to worry about it. I don't know why they're focusing on this issue. It's irrelevant to the matter at hand.
Because she's trying to confuse an already confused Supreme Court that doesn't understand the issue. So she's trying to do it where, okay, well, if we confuse them so much, then they'll just stick with what it's always been.
Yeah. Yeah, I think you're right. Just trying to muddy the issue as much as possible. And the main reason is because this has been one of the longest standing hoodwinks in American history. everyone knows this was the wrong decision. Everyone has known that birthright citizenship was not what was intended, except for people now who just haven't studied the issue. But people now, I think people even who support the idea of birthright citizenship, if they study the issue, will acknowledge that that probably wasn't what they were intending. If there's nothing at stake in the conversation, they'll acknowledge, yeah, they didn't mean that. Even if they like it, you have to. And it was the same with Roe, right? Ginsburg said this is wrongly decided. She is certainly pro-choice and believed that abortion should be available as a matter of right, but she didn't believe that Roe versus Wade was the proper way to approach that decision, and so she could be honest about that. But I think it's the same with this issue. There's no way to reconcile when you read the history and you see how immigration law works and you know the context of when this amendment was passed. You can't come to any other conclusion than birthright citizenship didn't exist and wouldn't exist for another 30 years till Wong Kim Ark.
I want to understand how you are responding to the government's argument that because temporary visitors and undocumented immigrants are still governed by their home countries, and in the government's take on this, you can't have you can have allegiance to two different sovereigns. Those groups can't have the requisite allegiance to be subject to the United States for the purpose of the 14th Amendment. That's what I hear the government saying. But I do think that that seems to rest on a different understanding of allegiance than what was in the English common law, and that when we understand what the English common law thought about allegiance, you can see that you can have allegiance to two different sovereigns at the same time. This kind of goes back to Justice Alito's questions. I mean, I was thinking about this, and I think there are various sources that say this, that you obviously have permanent allegiance based on being born in whatever country you're from. That's what everybody recognizes. But you also have local allegiance when you are on the soil of this other sovereign. And
This is ludicrous. It's a ludicrous idea. There is no situation in which the United States is going to conscript an unlawful immigrant into the U.S. Army because they have a duty of allegiance while they're present physically. Like that wouldn't happen. That's not a thing.
If I go to France, I don't have an allegiance to France that I'm gonna the war breaks out while I'm here, let me sign up. No, get out of here. No.
You can choose to, but they can't draft an American citizen, even if they're unlawfully present or lawfully present. Under no circumstances do you have an allegiance to that country in any sense. You cannot be conscripted into their military. And if you were, the United States would immediately enter diplomatic relations to try and get you back, or they may resort to a military action to extract you.
Yeah, she's just proof positive that incompetent people can still pass the bar.
Oh, yeah. The bar is all about how you organize information, and if you can process it quickly enough. That's it. It doesn't have anything to do, with your intelligence or your ability to practice law or make cogent argument.
I was thinking, I'm a U.S. citizen and visiting Japan. And what it means is that, if I steal someone's wallet in Japan, the Japanese authorities can arrest me and prosecute me. It's allegiance, meaning can they control you as a matter of law? I can also rely on them if my wallet is stolen to, under Japanese law, go and prosecute.
No, allegiance has nothing to do with control. Allegiance is an expectation of contribution back to the country when necessary. Like what the hell is this control thing? That has nothing to do with allegiance.
This is what happens when we take the Pledge of Allegiance out of schools.
Yeah, they all forget what it means. Like what an insane, all of this, what an insane proposition this woman is giving.
the person who has stolen it. So there's this relationship based on, even though I'm a temporary traveler, I'm just on vacation in Japan, I'm still locally owing allegiance in that sense. Is that the right way to think about it? And if so, doesn't that explain why both temporary
That's a crazy
residents
concept.
and undocumented people?
The exercise of jurisdiction has nothing to do with allegiance in that case. It has Japan's duty to protect the rights of the person who is under allegiance to it, the citizen that you stole from. That's where the duty takes place. They exercise jurisdiction over you by choice at that point because of their reciprocal agreement with their own citizen, not because of your temporary allegiance while you're there. This is a dumb argument.
I can see the Japanese prime minister reaching out to Donald, as she called him, and being like, "Hey, your Supreme Court justice over there is bad mouthing my country. Knock it off."
Yeah, hopefully she does. Because I would mainly just because I want to see Donald like get on Truth and trash Ketanji. Like, 'cause she's actually the remedial judge. That's what they call her around here. That's what I call her anyway.
Would have that kind of quote unquote allegiance just by virtue of being in the United States.
That's absolutely right, Justice Jackson, and that comports with the plain text of the...
And that's how you know the argument was wrong. Because anyone who says... Anyone who says that's right, Justice Jackson, you know then that the argument itself underlying that was wrong.
that is the blind leading the deaf.
14th Amendment, as it applies to everyone born in the United States, other than those subject to the exceptions that were baked in, a close set, you owe natural allegiance as a U.S.-born citizen. If you want to look at the parents of those people, and let's say the parents are foreign nationals but not ambassadors, the parents owe temporary allegiance.
Right, so the
under
babies
US
get the
common law.
permanent allegiance piece of this, and the parents get the local allegiance piece of this. So to the extent we're looking for allegiance, we have it.
That's right.
Thank you.
Thank you, counsel. Rebuttal, General Sauer?
That was dumb.
Thank you, Mr. Chief Justice. Justice Kavanaugh, turning to Lynch against Clark, that you raised didn't come up when I was talking about it. Keep in mind that we say that it's questioned at the time. It's questioned by a higher court in the same state. The state of New York, in the Ludlam decision in 1860, specifically said that someone who's traveling or sojourning abroad, though born in a foreign country, is not born in foreign allegiance. So obviously there is tension within that very state, and that's what contemporary commentators noted. And I make a more fundamental point about that. Lynch is not interpreting the 14th Amendment because it predates it. So it's not looking at the language of the 14th Amendment. It's looking at, what does the word citizen mean, for example, in the clause. So there's an anachronism to their reliance on it. And I think that turns to a point that Justice Alito emphasized. Once you get to that language of the 1866 Civil Rights Act, where Congress said not subject to any foreign power, clearly, we are no longer dealing with the British conception of allegiance, because Calvin's case and Blackstone say whether you're subject to another foreign power is irrelevant to whether or not you become a citizen. So again, the concession that I heard to be made that those two mean the same thing, which this court held in General Building Contractors, that the Civil Rights Act has the same scope as the Citizenship Clause of the 14th Amendment. Once you're saying not subject to any foreign power, Congress has clearly departed from the common law, the British conception of allegiance, that monarchical conception of allegiance. They have adopted the Republican conception of allegiance, and there's all kinds of evidence going back to the late 1700s that that's the way they thought about it. And there was a reference, I think, in my friend's presentation about the Marshall Woodworth treatise from the late 1890s. That treatise also, just like Lynch against Tark, the language they quote is actually describing the case or the law, the status of the law before the adoption of the 14th Amendment. So, but if you actually look at the treatises we cite again, I mean, Wharton, Morse, Justice Samuel Miller of this court, Lesser, Black, Hall, Winchester, Taylor, Westlake, Ballot, there's this consensus going from the time of the 14th Amendment onward, when they're looking at the specific question of temporarily present individuals in the jurisdiction, all those sources say their children are not citizens. And that goes both before and after Wong Kim Ark. You see a similar consensus actually in the congressional debates, where whenever it comes up, temporary sojourners, it's understood, the context indicates it's clearly understood that those children are not citizens. And I would therefore finish where I began with drawing a stark contrast and turn back to the first question that Justice Thomas acted. That Republican Congress in 1866 had a very, very clear understanding that the children of the newly freed slaves have the requisite allegiance to the United States. This was all about overruling the grave injustice of Dred Scott and making sure that allegiance was granted to the children of slaves. However, you have this contrast of a very, very strong, impressive consensus, both in the original understanding, in the congressional debates, and carry.
Can I just say this guy needs a fucking ice auger like to clear up his throat issue? My God.
No, he just needs RFK Jr. to come out and speak for him.
Yeah, it's fine. We'll get this issue taken care of. Holy shit! What affliction hit RFK Jr.? Like, what happened to him?
I have no idea.
Me either. Probably a COVID vaccine. Yeah, I mean it's brutal. I mean, he sounds awful.
Over into commentators for 50 years afterwards that the children of temporary sojourners are not covered. And for those reasons, we ask the court to reverse.
Thank you, counsel. General, the case is submitted.
Did you catch that at the very end, Nick? For that reason, we asked the court to reverse. So remember how they were asking earlier, especially KJB, or what is it? Brown was asking earlier to the ACLU. She's like, so the government's not asking us to overturn the ART case. And I'm like, wait,
yeah,
what?
they
are.
Have to.
That's exactly what they're asking for. So that's why I'm glad you said that at the end, is like, we're asking you to overturn this. And I think that's one of those things that maybe the justices didn't catch, that he was saying that, but.
Well, the weird thing was they asked him directly, are you asking us to overturn Wong Kim Ark? And I think his answer was, you kind of have to. Like,
no choice, right.
Because he's like, yeah, we're saying that the original interpretation or in the intent does not match with the Wong Kim Ark decision. Like here's why. And
I personally think Sauer should have said, though, at the whatever his come up for his rebuttal, just going, like, Miss Wang, what you've said is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be. And just quote the rest of the Billy Madison. Just saying,
yeah.
I award you no points, and may God have mercy on your soul.
And we're all closer to as dumb as Ketanji Brown Jackson as a result. No, it's I think Sauer did a good job though.
I was impressed with him. I really will say I was very impressed with how he did. I thought that it was going to go, that they were going to be very light with Wang on, their questioning for her. But I think that even some of the liberal justices were asking some kind of tough questions. Just keep out Sotomayor and keep out Brown, or Jackson. But yeah, I mean, other than that, I think that it was, there were questions that were hard questions on both sides. And I thought that Sauer definitely did a good job answering the questions and sticking to the point.
Yeah, I agree. He wasn't, there was no pomp and circumstance to his presentation or his, responses. And I liked it. It was straightforward. He stuck to the issues. He didn't get hyperbolic or frazzled in any way. You could tell he had nerves going because he's before the Supreme Court always, and it's a highly publicized case, but they were
not to mention the president's there, so he's probably shitting his pants.
He's like, I will be fired if I don't do this right. But no, I think he did well. I think the ACLU lawyer did a terrible job, and I try to be fair and say, even if I disagree with someone, I think they at least presented their case well. I don't think she did. And I think she overtly misrepresented his position at least once that we talked about. And I think more than that. And she clearly misstated the case law. And the fact that she misstated Wong Kim Ark is crazy. That she would stand there before the justices and say that Wong Kim Ark isn't about domicile is insane. Like, how can you, with a straight face, do that?
22 times. How can you? Yeah, no.
Yeah, how many pages is Wong Kim Ark? I'm going to check real quick. Because, like, Wong Kim Ark decision. Let's see if Justia has it. Here we go. This is...
It's... Not at all.
Shit, I didn't grab a PDF of it.
No, I just found it on Justia, but it goes from 649 to 6.
Here, I'm pulling up the Library of Congress document on it. It's 84 pages with, is there a dissent in this? 84 pages is pretty long. I'm surprised. But the thing is, especially back in the 19th century, if you have an 80-page document, what they're doing is creating law that didn't exist.
Oh, yeah.
I mean, that's it. I'm looking to see if it switches to dissent. I think I can just Control F this thing.
Yeah.
Okay, yeah, so there is a dissenting opinion.
Looks like maybe halfway.
Let's see. Here we go. Yeah, Chief Justice Fuller. So this is on page 57 is where it switches to the dissenting opinion. So 57-page opinion. Nowadays, you're lucky to get anything short of 3 figures. It's fucking crazy how bloated these damn things are. I hate it because I want to cover some Supreme Court decisions, but I don't want to sift through 100 pages of text. Like, and then you get a 35-page dissent, and you're like, "Oh my God, kill me!"
Shove it into ChatGPT and let that break it down for you.
Yeah, it's tempting. It's tempting to do so, but it's like I wouldn't trust their answers.
No, it loses a lot of the context that it really needs, and that's why. I mean, yeah, I've heard, AI is going to replace lawyers. Good luck. All right. Because
yeah, I want
just
to
ask
try
the
out
lawyers that have used AI in their pleadings and stuff that have gotten just,
they get annihilated by the court
Yeah.
when they do that. I want to try out Westlaw's AI, but it's really expensive and I don't have an actual business need for it yet. So I don't have the subscription because I think
Clio's gotten into. I think Clio started to do one as well. That's similar. Because they're just acquiring all these different things, so they can just be a huge monopoly, anyways. But
yeah, it's. I think they quoted me on the plan to have all 50 states on Westlaw plus to have the AI assistant. It was like $1,600 a month, and it's like I don't want to pay that right now. I don't want to pay that.
It sucks being one of those solo practitioners, doesn't it? Where we got to cover everything.
Well, and the way that I use it because I'm using it for journalistic purposes, right. I need to have all the states. Like that's the benefit for me. If I was just practicing, I would just have Minnesota and federal. And, I wouldn't need the 49 other states. But when you tack those on, the price just goes straight to the damn moon. But, okay, we got a couple quick chats. Boxfort Defender says Trump said he's not going to attend Geneva Convention anymore. So, ... Yeah, but the U.S. is still party to parts of Geneva. I think it's like Geneva 4 or something, and 7 we're not. There's a couple we didn't sign, but we are party to the rest of it, and that is binding. So we
can't come out of it.
We can choose not to attend, the actual meeting or whatever, or not send a representative. We could choose to not participate in the United Nations. We can do all those things. But what we can't do, we are still subject to international law by treaty, and that treaty is binding. Now, what the enforcement mechanism is on us violating the international law would be questionable. The U.S. is in they're one of the few nations who have the unique capacity to decide to violate international law, because who's the cop who's going to arrest us? You know, if you're a small country, you violate international law, you can get punished. The U.S. People have to decide whether they want to mess with punishing us, and we have to determine if it's even, like, if that would even bother us at all. Like, whether this small country put sanctions on us, who cares? Kind of Shady says, balls or no balls, member for 7 months. Okay, they wanted me to ask you this for the whole time. Are you familiar with a futanari? Do you know what a futanari is, or a futa?
No.
Okay. You're familiar with anime, right? Like, not you don't have
not
you
a
know
whole
what
lot,
it
but-
is. You know
Right.
what it is. Okay, so futanaris exist in anime primarily. It's a female character that has a penis. Also,
So it's Aphrodite.
kind of like, it's kind of like that, except you know, they have a little bit of a different rules. One, the penis is always massive, so like that's one thing. The question is, so assuming the existence of futanari and recognizing what they are, should they have testicles or not? What is the correct, like, what is the proper answer? That's the question that you're supposed to listen. My chat has complicated
Your
problems.
chat's weird.
Yeah, I know. I'm sorry.
Your chat is weird.
But that's what they've been asking.
As a
me.
longtime member of that, I can say that proudly. But yeah, I'm not my cup of tea, so I'm not going to answer.
Oh my God, he refuses.
That's right.
Proper answer is balls. Anyway, like, of course. Of
You
course.
can't have a penis without balls. I mean,
Right, that's gay.
Yeah, right.
Yeah.
So
100%.
Yeah, if you got to go with one of them, but
Well, see, now you did answer.
No, I never said it. I never said balls or no balls.
I thought you just said you can't have a penis without balls.
Either-
Like,
Okay, then yeah, but now you're getting into the question of, you know, at least the difference is we all know what a woman is.
that's true. That's true. Unfortunately, Charlie Kirk didn't, you know, like, or was that Matt Walsh? I can't, who did the, what is a woman?
Matt Walsh.
That was Matt Walsh.
Yeah.
That makes sense. I'm not surprised that he doesn't know what a woman is.
No, as a long-term Arizona resident, Charlie Kirk is
He's a hero, man.
He is, man. He is, and they're gonna name. There's supposedly legislation to name rename a freeway after him out here, but I don't know if it'll actually happen because we apparently have a Democratic governor who wants to appease.
It's crazy.
everybody.
It's
So-
crazy. He was one of the most, I know some people out there will say anybody and everybody is hateful or whatever, but he was one of the most approachable and respectful, you know, the articulators of the conservative ideology. He was straightforward. He invited anyone to speak. He respected their opinions. He stood by his own convictions, and he didn't do so with insult. He didn't do so with malice. And he, you know, it was always, let's have a conversation. And at the end, we walk away in peace after having exchanged ideas.
And anybody who says anything otherwise never watched his full videos. They only
Ever.
watched little clips that were taken out and used to portray him in that light, because otherwise there's so many times that, you know, he would actually go against that whole bit, you know, where they're like, oh, he was a racist. No, actually he wasn't. He was far from it, because he would actually say, like, why do you feel that way? Because I don't feel that way. And that was just, you know, like, he was a hero. You know, so
he was on track to become president of the
he would
United
have been
States.
absolutely. He would have been the youngest president of the United States. I guarantee it. He would have been the youngest president of the United States.
Yep. Finally taking it back for the whites. Damn it. They took it away from us. I kid, of course. No, his death actually really unexpectedly affected me. Like I generally have compassion for people and stuff like that, but his death hit me like in a way, and I wasn't. I liked Charlie Kirk, but I didn't like follow him. I didn't really watch his stuff. I just agreed generally with his approach to things, so I was a fan. But I couldn't say that I had like any sort of parasocial connection or anything, because I just like, he was just there and he did his thing and that was fine. And
Right.
I hadn't quite reached the the S tier commentator area yet to where I'd get a chance to meet him. Well, I think I could have, because I could have gone to a couple of the major like I could have gone to CPAC or whatever, but I hadn't taken the opportunity yet. And when he died, it was like, holy shit. And part of it was very much like, I'm not on the level of Charlie Kirk, but I do public appearances. I do
Right.
public events, and I, am happy to speak my mind about it. It's like, holy shit, that could be me or one of my friends. Watching that was pretty tough. And I had a lot of respect for him. So that was really shitty, in that capacity. And everything that's happened afterwards has been such a circus. I hate it. Like, Erica Kirk, I don't know if she's a scumbag or not, like, but I also don't care. And like the fiasco around it, it's like, y'all have just completely taken away everything, like,
That he stood
about,
for.
right. You're completely cheapening, his death and how his death could be used. Could be used to motivate people, to energize people, to stand up against this shit, to have a universal condemnation of political violence. And instead we have fucking Candace Owens like, no, it's the Jews, buddy. And it's like, God damn it. Can we just like revel in the fact that someone did something revolutionary, changed the way that political conversations happened, and he did so peacefully and was respected by both sides? Can we have that for just a minute? No, it's got to be something insane that follows.
Yeah, and I mean, and I think he'd be rolling over in his grave if he saw what was happening with TPUSA right now, with how it's being directed. Because I'll tell you right now, love the man or hate the man, there's no way if Charlie Kirk was still alive that Kid Rock would have been performing at the Super Bowl halftime show with some of his music and stuff. But Kid Rock's a totally different person now, and I get that, but still, it's just one of those things that if Charlie Kirk was alive, he wouldn't have sang "Ba Wada Ba" or whatever he sang with, at the start of his his producing of that show. But no, I followed Charlie Kirk, and then my best friend texted me. It's like, Charlie Kirk got shot, and I was like, what? No. Like, this is before we knew he was gone or anything, and I was just like, I was stuck to the news all day that day, just like watching, because I kept waiting for him, hopefully to say that he was going to pull it, because they tried to take out other people and weren't successful, but then they were successful with this one, and it just, that broke me.
I was really hopeful, and then I saw the video and I was like, oh man, yeah, he's not pulling out of that.
I when I saw the video, I was like, no, there's no way he survived that at all. Like that, there's just the way that,
that was arterial.
Yeah. Now, granted, I don't know. What do you think from the legal aspect of what they're arguing now about the bullet not matching?
Oh,
that's not going to.
Here's my conflict with that question. They're throwing the kitchen sink at the judge for continuance.
Absolutely.
When I look at it, if I'm objective about everything and I just take a step back and I go to law school question, they 100% should have a continuance on this issue. Not because of the bullet, though, just because the overwhelming weight of discovery and taking their assertions on discovery violations Brady violations essentially as true, taking those assertions as true, they're definitely going to need time. And 6 weeks is not an unreasonable request. an extra 6 weeks to review the massive amount. And if they're still waiting on two at minimum one on DNA, if they're still waiting on those at this point, then their request is entirely reasonable from a law school question perspective. But practically in the criminal system, they know that the state does this all the time, and what the state has done is wrong, but not unreasonable in the context of how the state always acts. You'll get an expert report literally the day of trial. Go to the judge and be like, Judge, we haven't had a chance to review this. And the judge will say, no, we can move on. Like, you can do it. You've got time. And it's like, no, they don't. They don't have time. They'll have 2 days, like, until that witness is called, but they'll be in trial both of those days and expected to acquire an expert, have them review the report and generate a counter report and be ready to testify. It's that happens all the time. So,
and you got to remember that Utah is also the only state, I think, in the country that allows a victim to have a speedy, like, to request a speedy trial. No other state does that, and I think that's part of the reason why. Yeah, Eric. But I mean, I've got a lot of questions, which is again why I said kind of whenever I first come on board, like that's one of the ones that I really hope stays public, because I really am going to stream that one, because there's a lot of questions that I want to see all the evidence. That I mean, if the guy's guilty, then by all means. But if he's not the one that did it, then we need to find out who the real one was. And I think there's going to be a lot of pissed off people if we can't find out who it was.
The thing that I say is this: he may be not guilty because of some procedural issue, any sort of defendant technical a violation of rights or whatever that prejudices the defendant. He may be not guilty from something like that. But from what I've seen so far, and now we haven't gone to trial, so I can't say this as definitive, but from what I've seen so far, it seems like the evidence against him being the shooter, pulling the trigger and shooting Charlie in the throat is overwhelming. It seems like it. So I would be very surprised to see a defense. I'm going to be surprised to see the defense strategy of he didn't do it. I think the defense's goal here is to keep him off of death row. I think that's, I think that's their main concern. I think that's their main expectation, is to get him a life without parole sentence versus a death penalty.
And that's the same thing that they were looking for that guy in New York, the one that shot the insurance guy, the
Mangione.
Yeah, and that's the same thing. They just wanted that off so that way death. He wasn't facing death. Now he's not facing death. Now they're like, okay, we can make this, go a little bit slower. So,
yeah, we'll see. I'm interested to see the theory, but they know that the ballistic argument is like very weak.
Just like they had to know that the argument of getting the entire defense team kicked off was a weak argument as well. But you know what? I respect the judge for actually taking the time and making sure that he laid it all out, because that's an appealable issue. So, or a special action if they need to get it before they even go to the jury or anything. So yeah, of course he's going to try and do that. And I respect the judge for making sure, like, look, I could have just ruled on this instantly, but I wanted to take the time and actually review everything and listen to everything. So,
yeah.
But hey, it was nice meeting you. I do have to
man.
run because I got to help my wife get my kids in bed. But
yeah, I gotta bail too. So, but thanks for joining me, and keep in touch. Sure. Keep in touch, and I'd love to have you on again. It was a lot of fun.
Yeah, for sure.
All right, brother.
All right,
nice to meet you. Peace.
Yep.
All right, guys. Well, that guy was pretty cool. I think maybe he can come back. And I really always like having another lawyer on to do these things. I don't like to ask other lawyers to come on because I don't like to impose on what they're doing, and I'm not paying them or anything to come on my show, so I don't like to ask people to come on, but I'm happy to have guests. So it was really cool to have him say, "Hey, have me on for this," and I think it really added to the commentary, and I think it always does. So I am working on changing that. And getting more guests back into the rotation to do some of this stuff. But things are always, one step at a time. But it was nice meeting him, and it seems like he's someone who could maybe hang out with me a couple other times, maybe on some of these trials. And I especially love it during trials, because it's just great to have people to bounce ideas off of. Okay, here we go. They can't be stateless because they are under the jurisdiction and allegiance to their original state. If they come to this country without permission, they're not under our jurisdiction. They're still under their own state's jurisdiction and their own state's allegiance. So at that point, the child becomes still a citizen of that state. That's how. When you have a child born to parents who are citizens of state, the child it adopts the citizenship and domicile of its parents. Children don't have the capacity to make the choice until they are 18, outside of specific situations, about their own citizenship. They don't. They can't renounce their citizenship and choose a new one, again, outside of rare and specific cases. They have to wait till they're 18 to do that, or they have to have, their parents involved in that decision. So there isn't a thing where a child is born stateless. They're born with the same state allegiance as their parents. Them being here unlawfully does not change that allegiance to here under any circumstance, unless we were to write a law that specifically does that. So if we overturn Wong Kim Ark and eliminate birthright citizenship, and someone unlawfully present comes into our country and has a baby, that baby is not stateless. That baby is under the same state allegiance as its parents. So that allegiance agreement, allegiance protection dichotomy that was brought up several times during the arguments, that is reciprocal. It's an agreement. It's a contract. You've heard it called a social contract, I'm sure. The Constitution is a contract between the country and each citizen. We promise you this. We promise you this as the exchange of your citizenship and your allegiance to our country. That is the contract. Here you go. Here's what you get with it. And here's the expectations that we have, that you'll follow the laws of this country, that you will submit yourself to the jurisdiction of its courts, that you'll abide by the rules of each state as you go through them. That's the contract that we sign when at birth. And we have the ability to renounce that contract, to back out of it, and to choose a new one. There's a process for it, but we do have the ability to do that. If you're here unlawfully and you have a baby, that contract doesn't exist. There is no privity, is the word. 999MHer says, what about an issue of newborns? Oh, wait, I just read that one. Okay, it was there. I think that's all the super tips and super chats that we've got. And I don't think, I'll double check. I don't think there were any Rumble rants that I missed. Okay, I think that's it. Okay, perfect. All right, guys. Well, hey, it's been a much longer stream than I planned, but I hope you enjoyed it. I'm gonna enjoy making a shitload of clips out of this one. We had a bunch of different subjects happen, so I'm going to try and segregate out, everything and put some videos and clips up for it. If you guys see those clips, if you click on them, I really appreciate it. YouTube really cares if subscribers are watching the clips that channels put out. So it helps me a ton if you want to watch them. Obviously, if you don't. But if you do see them and you just check them out, I try to keep them short. So it helps a lot because it helps it then decide to send it out to other people. Like that's how the algorithm works. It first looks on if people who watch the channel choose to watch those clips. I try to make them good and punchy. I don't just throw up garbage if I can avoid it. So, but if you do watch those, I always appreciate it. If you decide to share them, oh my gosh, you're my hero. So, thanks a bunch. I will catch you guys later, and I hope you have a good one. Thanks for watching. Peace. Peace.
So pour out an odd bag about more of that pride. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Planning tonight. From the wide shores of Nairn to the hills of Glenlivet, there's no one who explains the thought better than Nick. So pour out a glass for the ones who have passed to make the love of